want them back. You being intimidating. What they gonna say? I Ray Bandit, they don't put the gloves on no more. He's still right now.
Y'all good? I'm gonna say one more. I gotta go. I'll be back when I leave, guys.
It wasn't trying to do it. I put it back. I guess if I set in over that night. Okay. It might be in there to let you know. You should be cool. Okay. I used to be
All right, good afternoon, council's interested parties. We're back on the record of the matter of the state of Georgia versus Cleef Adams et al. And 22 SC 183572. Mr. Stillwell, Mr. Botts, and Mr. Sharp. Good afternoon, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard. Good afternoon. All right, Mr. Kendrick and Mr. App. Good afternoon. All right, Mr. Ewing and Mr. Matthews Jr. and Sr. Good afternoon. All right, Mr. Nichols, Ms. Westmoreland, Mr. Harvey. Good afternoon. Mr. Ryan and Ms. T. Williams. Good afternoon. All right. Okay, Mr. Smith, Ms. Hilton, Mr. Atkins, and Ms. Loeb. Good afternoon. All right. All right, Deputy Hammer, all our jurors present?
Yes, sir.
Okay, all right. Anything I need to take up before we call our next witness?
Your Honor, just wanted to know if the defense had an opportunity to look at the transcript and if they had any.
Transcript of what, madam?
The transcript that we provided yesterday for the jail call that was played, 175C.
All right. Counsels, anybody wish to be heard on the issue? Ms. Hilton, you want to repeat your statement?
Sure. Yesterday, the state provided transcriptions of the jail call, State's Exhibit 175C, and wanted to know if the defense counsel had an opportunity to review that transcript, and if so, if they had any edits or if they did not have any edits.
I guess I'm a little confused, but we talking about the jail call that was actually played yesterday?
Within the context of the interview between Mr. Bean and Detective Quinn.
Correct, because
and I just, because you all had an opportunity to take a look at that transcript yesterday, we just played the tape. What the state's asking to do today, I assume, is to go ahead and potentially play that again or play it and provide a transcript. And I would of course, give an admonition at that point in time.
Well, I'll speak for Mr. Williams' team. I think I may speak for everyone else. We haven't reviewed it just because we didn't think it was.
Well,
and since we played the tape.
that's a you problem.
Well,
Because you had it since yesterday. I didn't play it yesterday. I didn't provide them the transcript yesterday because you didn't have time to review it.
right, we played the tape. We played the recording.
Yeah.
And I think the court's position was, the recording's here. True, we haven't had an opportunity to review it, but we played the recording. So
Okay.
I don't think there was any indication on our position, on our part, that we need to readdress the issue of the transcripts.
All right. Let me hear from this. Let me hear from the state on that particular issue.
Yes, Your Honor, I believe the court was going to either do one or two alternatives. The first alternative was to give 35 minutes or 30 minutes. I believe that was the request in order for defense counsel to review the transcript. And the alternative, we made a decision to play it without the transcript with the thought that defense counsel would review it because we do intend on using that call again and playing that call again. That's something that may or may not be addressed today, depending on how far we get with Detective Quinn. So it's something that could come up by Friday, but we would like defense counsel to review it. And if they have any edits, let us know because the state would be intending to use that transcript.
Okay. Mr. Adams, anything further?
We'll go ahead and we'll review it.
Okay.
If any anticipation that it probably won't be an issue today. I understand how to try that case, but I think I will just say this. I think that our understanding, the defense understanding, was that the court was going to go ahead and let the recording be played, so there was not really a need for us to review a transcript that wasn't going to be used.
Yeah, and you're right, sir. And I think that the state's telling you they're going to potentially ask the court to go ahead and consider the transcript. They're asking you all to review it for accuracy and edits. And of course, I'll accept any other objections at that point in time. And if I should decide to give or play the tape with a transcript as an aid, I'll give the applicable Uniform Superior Court rule tape and transcript instruction or admonition. Okay.
We'll go ahead and we'll review that.
Okay. All right. Anything else?
Nothing else.
All right. Let's summon our jurors, please.
Just for the future, probably we're having all sorts of activities, which affects our ability to look up case law.
You at your own hotspot? I take it from that.
I've always had trouble with my own hotspot.
I would just suggest that redundancy is always a good thing. I don't know how the public Wi-Fi here is in the courthouse, but we have added a hotspot for you all's use only.
And that's been working until today, at least in my experience.
Well,
Something's happened today that it's gone down.
I can't tell you why. I can only make a phone call and
So I'm asking.
and I can maybe inquire about that. So, Mr. Kearns, can you call Ms. Omana and the dependency and see if we can check on that?
Yes, Judge.
Okay, all right. Mr. Steele? Was that it, Mr. Sharp?
Yes, Your Honor.
Okay.
I don't know the context, so I'll just ask him for it since it came up. I said, I don't apologize. I don't know the context, so I don't know the objection to be made, but replaying a recording that has been played already would, in my opinion, be cumulative and none of the speakers are here. But again, I don't know why that would come up.
Yeah, let's see what the state offers it for, and I think that's a little premature at this point in time.
I was just answering because I've heard you say any other objections. So
That's at the time that you all have have an opportunity to take a look at the transcript. But if the tape's played, depending upon the foundation, depending upon what it's issued for, I'll make a determination at that point.
And then can we just approach for about 40 seconds on a matter?
Okay. Are they good, Ham?
Like, I'm using the restroom.
Okay, all right, well, just tell them to get ready, okay? All right.
for the jury?
All right, thank you, Deputy Ham. All right, ladies and gentlemen, please be seated. Members of the jury, good afternoon.
Good afternoon.
All right, sound good. Okay, ladies and gentlemen, without further delay, we're going to continue with the presentation of the state's case. So, ladies and sirs, call your next witness.
Thank you, Your Honor. The state calls retired Detective David Quinn.
All right, summon Detective Quinn, please. All right, Detective Quinn, good afternoon, sir. Afternoon. All right, come on up to the witness stand, sir. And before you sit down, if you would be so kind and turn and face Deputy Ham, be sworn as a witness.
Raise your hand. Do you swear to the testimony you're about to give forward the truth, the whole truth, nothing but the truth, so you got?
I do.
You may be seated. Can you state your first and last name and spelling of both, please?
David Quinn, David Quinn.
And good afternoon. How are you employed?
I'm retired.
What are you retired from?
The Atlanta Police Department.
And how long have you been retired from the Atlanta Police Department?
Fully since 2019.
Okay. And when you say fully, what does that mean?
So I joined the Atlanta Police Department in 1985 when I was 20 years old. And I stayed until 2019. So I did 33 years and some change. After that, I got into the true crime TV business, which is what I do now.
Mm-hmm. And tell the jury a little bit about your time with the Atlanta Police Department over those 33 years.
Again, I hit the street when I was about 21 years old, 1986, after having been hired at 20. And I went straight to Zone 3. I don't know, Zone 3 was back in those days, Southeast, Southwest Atlanta. I stayed there 10 years in probably the highest crime district in the city at that time. After those 10 years, I don't know why, somebody sent me to Bankhead and I went to the Zone 1 precinct and I worked there for another 5. In my 15th year, after working those high crime areas, somebody promoted me to detective and they sent me straight to homicide, which sent me right back to those same neighborhoods in Zone 3 and Zone 1. It's like going home. So.
And let's talk about your 10 years being in Zone 3. Did you have the occasion to patrol the entire Zone 3 or were you assigned to a particular section of Zone 3?
Well, I was assigned Zone 3 A sector, which was that area around McDaniel Glen Housing Project, the Pittsburgh Civic League Apartments, Pryor Road, but there was a lot of bleed over. In other words, I wouldn't just work one specific area in downtown Atlanta. I would also branch out as far as Gilbert Road, which is at the county line to Clayton County. So it was the busiest precinct at the time. So you kind of scattered all over.
Okay. And you said it briefly, as a homicide detective, did you unfortunately have the occasion to investigate homicides within the Zone 3 neighborhood?
Absolutely, every month, usually.
And based on your time in Zone 3, if you could describe the Zone 3 community for this jury.
Zone 3 in community, from the time that I worked it in the mid 80s, all the way until I was an old man in, the mid 2000s. It's a rough, busy neighborhood, but there are pockets of diversity everywhere. You may have truck drivers, you have doctors, lawyers, but you also have the quote unquote marginalized communities are also in Zone 3. So it's a mix. It's not one thing.
And based on your interaction of having different type of community members within Zone 3, how would you describe the residents of Zone 3?
The who?
The residents.
The residents are hardworking people. I grew up out there with them. I feel like, I am Zone 3 because I saw so many different generations get raised up out there. And I feel like I was only 12, I was a boy, And when I left, I was a grandfather. So that was my life.
Now, I'm gonna take you back to your time as a detective in the homicide unit. If you could tell the jury, what were your primary job duties and responsibilities?
When I went to homicide, I learned quickly that my responsibility was to investigate crimes that involve deaths at the hands of other humans. I had worked murder. That's primarily what I worked. I worked with about 18 other detectives, and we were in a rotation. Whereas you would catch a homicide, respond to it, you'd have about a month to work that case up. And once you've worked that case up, you would go down to the bottom of that homicide list. But you also, they were giving us the responsibility to actually handle cases that involve special investigations. In particular, police officers' use of force, shooting people, anyone that dies in custody. We handle those investigations. Sometimes we even handle corruption investigations on the department if in fact there was some kind of conflict in internal affairs.
So speaking specifically about having to do those special investigations, specifically the officer involved investigation.
Our Twix Salted Caramel Concrete is the salty sweet treat you know you deserve. Dine in, drive through, order online, or use your Freddy's app.
Whether or not an officer had the legal authority to use his gun in a deadly way. I investigated deadly force.
And to your knowledge, is that responsibility of investigating officer-involved shootings still the responsibility of the homicide unit?
You know, when I was on the way out, it changed gears. They decided to let the Georgia Bureau of Investigation handle those shootings. I guess they didn't want the actual agency to investigate itself.
Somebody say something?
I did, Your Honor. I said objection, speculation.
I will objection.
When you are assigned as when you are assigned an officer-involved shooting, if there is an underlying crime that occurred before the officer-involved shooting, do you investigate both the underlying crime and the officer-involved shooting, or do you are those two separate investigations?
No, you have to work both. You've got to understand the reason why the officer was there in the first place, why he pulled his gun, why he used deadly force. Sometimes it's not involving a weapon. Sometimes it's physical force. So you must also investigate that crime as well.
Now, in your experience as an investigator, do all investigators investigate cases the same way?
Oh, no. It's just like any other walk of life. I mean, everyone has their own style. And usually your style comes from how you carry yourself in the street and your experience out there with the citizens, in this case, the citizens of Fulton County, City of Atlanta.
Tell us a little bit about your investigative style.
Everybody calls me old school.
I'll overrule the objection, Mr. Steele.
I am Atlanta, and I feel like every case I work is a story, and I've got to report back, the information from that story. I always say when I work my investigations, I want to have on a belt and suspenders. I want to make sure I got everything. And sometimes, commanders and supervisors don't like that. I mean, I take my time, slow and methodical with how I work my cases. I don't move very fast.
Faces. I overrule the objection, Mr. Sharp.
Thank you.
You could say.
That's pretty much it. I just try to keep, you don't get all the answers when you work in investigations like they do on TV. But what you do is you try to get as much as you can, and you miss things. I miss things on every investigation. And so you have to take your time to make sure you have it right.
When you're conducting an investigation, generally, what type of evidence are you looking for, say for your homicide cases? What type of evidence do you want, are you trying to gather as a part of your investigation?
I mean, first and foremost, I want eyewitnesses. I want humans to give information that could lead to some kind of inroads in closing this case. As I got older in the department, technology became a useful tool. We've always had fingerprints. You want fingerprints. DNA became a really big deal around 2002. I've watched everything change, but I always, with any kind of testimony that I receive from a witness, I want to get something to back it up, something tangible that'll vouch for this person that's an eyewitness seeing something. But I really like eyewitness evidence. A lot of people don't, but I do, because the community, that is the witness.
Now, in your time as a homicide detective, have you had the occasion to interview suspects?
Absolutely.
And tell the jury a little bit about your interview style.
I try to keep my interviews.
Overrule, Mr. Sharp. Have a seat.
I try to have conversations. I mean, from these conversations, I try to have them make sense. You know, I don't want it to be overbearing. Sometimes those conversations, those interviews can get heated, but you want to build some kind of rapport with the person, whether it be a witness or a suspect, and make sure you're getting good information.
You have an objection, Mr. Steele? What's the basis? All right, come on up.
May I proceed, Your Honor?
Yes, you may.
Let me ask you this, Detective Quinn. Over the course of your 30 years, how many people have you interviewed? Just roughly.
I mean, thousands. I mean, I can't put a cap. I can't put a number on that.
Okay. And you talked a few moments ago about building rapport. Tell the jury, why is it important to build rapport?
You don't want your interview to be adversarial. You want people to be calm and give you truthful testimony that you can verify later.
Mr. Steele, you gotta pose an objection and then you gotta tell me a basis, because selling your honor doesn't let Ms. Weaver know who you are. So please go ahead and objection and tell me your basis.
I have a motion. I have a motion.
All right, ladies and gentlemen of the jury, can I get you to step into your headquarters for just a second? Detective, can I get you to step outside for a minute? All right, ladies and gentlemen, our jury has left us and our witness is off the stand. Yes, Mr. Steele, what's your motion?
Your Honor, I tried to preempt it at the bench. It's exactly what I asked. And I'll wait for Ms. Weaver if the court needs it for the exact quote. But Detective Quinn just said, upon questioning the district attorney, why is it important to develop a rapport with a witness? And the answer was something to the effect of, to get truthful information. No witness can talk about veracity or truthfulness or believability of anybody. That's what I tried to say at the bench. That's the entirety of this testimony so far. I'm moving for a mistrial on Mr. Williams because this gentleman interviewed a big witness in this event. The only witness that puts Mr. Williams involved in this event. And now it's important to get truthful information. I don't know how you wipe that out. Are you going to tell the jurors to ignore that last comment? That's what you're going to say? And I warned it. And I was at the bench and you did not want to hear from me more than you did. You told me to step back. But Your Honor, I've been doing this too. I anticipated it wasn't that hard to do. I'm moving for a mistrial. And I did it at the proper moment.
All right, Ms. Hilton?
Your Honor,
Have a seat, Mr. Sharp. Let her finish, okay? All right, remember the Harvey rule is still in effect, so have a seat.
Your Honor, as it relates to Detective Quinn's response, he did not talk about a specific witness, truthfulness, or veracity. He said, in general, what I'm trying to do is to find the truth. And that is what you do in an interview. You're determining whether or not what the person who's speaking to you is credible, if they're providing credible information. Your Honor, even in this case, when you listen to the interview that has already been admitted, Detective Quinn already tells Agent Bain, I don't think you're being fully honest. So he's not talking about the veracity of any one witness. He hasn't even talked about any witnesses yet. So for defense counsel to deem or ask for a mistrial at this juncture, given this testimony, we're going to ask for you to deny.
All right, I'm going to deny the motion. Summon our jurors, please.
Before the next question is asked, I have to review my motion.
It's noted. I'll make it, yes, and I preserved it. It'll be continuing. Mr. Shard, if you ask me that one more time, okay? No, I did. Listen, everybody gets the same objection, okay? Unless there's something else.
If you want to take again, you have to do it.
Your Honor, previously you informed all defense counsel that motions for mistrial were not subject to the Harvey rule.
No, I
That's
didn't.
why I'm doing this.
No, I
If you
didn't.
tell me that motions for mistrial are now subject to the Harvey rule, and that's on the record.
I don't recall my saying that they were not, so.
Respectfully, I recall that, but I will just rely on the Harvey rule from now on, if that's clear for the
I'll
record.
assume it for everybody then, unless you opt out.
Thank you, Your Honor.
And just in case there's any confusion about the prior testimony or prior arguments that were made for motion in this trial, my understanding from the court's ruling today is that it applies to all defendants.
Yes.
Thank you.
All right, summon our jurors, please, sir.
Your Honor, is it okay if we pull the mic back a little bit on what we're saying? We hear feedback a little when we, when the witness responds.
I don't want you touching my microphone
I will not.
because that's the exclusive purview of Miss Weaver, okay? So,
I think there's a little bit.
it's okay with her, then you have carte blanche, but short of that, leave it alone.
Your Honor,
Sir,
would the court consider my previous request for a continuing objection now in the same bolstering?
yes,
Irrelevant?
well, I'll just give you a continuing objection, okay? At this point.
All right, Mr. Ruth. So the President of California.
All right, thank you, Deputy Ham. Ladies and gentlemen, please be seated. All right, you may continue your examination, madam.
Thank you, Your Honor. Detective Quinn, in your interviews with citizens or with suspects or residents of the community, do you curse or use language that some may deem offensive?
I would think, yeah, my mother in particular.
And is that just your style of talk and speech?
Yeah, I mean, that's just how I talk. And I think it's more like the vernacular of the area that I worked in all those years.
I want to direct your attention to September 11th, 2013. Were you assigned to the homicide unit?
I was.
And did you have the occasion to respond to 2745 Old Hateville Road, Atlanta, Georgia, Fulton County?
I did.
And did you arrive with other officers?
I did.
Do you recall now who you arrived with?
Well, I was riding alone, but other homicide detectives went to that scene. You had Detective Vince Velasquez, who's my longtime partner. You had Detective Summer Benton, my super. Is that me? You had a contingent of other support staff. What's going on?
Say again?
It's really ringing in my ear big time. I don't know what it is.
Hopefully she'll finish it.
Okay.
That's the flow.
I'm pretty loud. I don't think I need it.
About what time did you arrive at that location?
I got there about 12:30 in the afternoon.
And what was the temperature and weather like that day?
It was hot. From what I remember, I mean, it's Georgia afternoon, so I know it was a little warm out.
And why did you respond to that location?
Well, I got a call because I was told by dispatch that an officer had discharged his weapon and I need to get to that scene.
And while you were responding to 2745 Old Hateville Road, did you learn that there were other areas that were active scenes at that time?
Absolutely.
How many other active scenes were there?
It was about 3. You could almost say 4, but 3 that were going to be necessary for that investigation. They were going to have to be processed.
And what were those three?
So you had 2745 O'Haydeville Road, which is the Summerdale Commons Apartments. There was, what I was told at the time, that's where the incident occurred, where the officer discharged his weapon. Then you had a house directly across the street from there where there was damage to a residential home right there on O'Haydeville Road. And then you had a third scene, which was 126 Cleveland Avenue, which the Cleveland Coin Laundry, a car had crashed into it. So I had a bunch of scenes going.
And roughly, how far were each of those seats from each other?
They were within about 75 yards. If you just do the whole perimeter, it's kind of disjointed, but they were all kind of right there.
You may. You've shown that document to defense counsel, correct? Okay.
Marcus States Exhibit 158C.
Sure.
Do you recognize Exhibit 158?
This looks like the area I just described, roughly, yeah.
And is that a fair depiction of an overview of that area you kind of described where you responded to on September 11th, 2013?
I would say so.
Around this time, state like Tennessee Exhibit 158C is that.
Any objection to states 158 Charlie? Anyone?
No, Your Honor.
All right. States 158 Charlie is admitted and may be published as you see fit. Yes, ma'am.
And looking at this Exhibit 158, roughly, and you can either do one of two things. You do old school, like you like to say old school and point, or you can use that computer. I'll let you decide.
Oh, wow. Okay. I think I'll do the finger action over here.
Okay, so if you can click to the left, it should pop open to the bottom. Just tap the screen. All right.
Oh, wow.
You have a pen over there to the left.
Right here.
Yeah. That should give you a pen. Can you circle on there? Do you see where it says Summerdale Commons? Or Summerdale Apartments? Commons first. And then Summerdale Apartments. on here where it says the Skyline Laundromat. Okay. Are those the three, roughly the three areas that you just kind of described for where you, those three active cities?
Yes, ma'am.
Describe to the jury what was the scene like?
Like opening day at Six Flags. It was crazy. I mean, it was fire engines, police officers, blue lights going. Everybody talking to me at one time, you know, which I'm used to, but this was a really big scene and it was really active.
And once you got there, what did you find? What did you observe once you responded to the process?
When I got there, I wanted to speak to my supervisor and just try to figure out what was I dealing with here. Give me an overview. The first place I pulled up to was 126 Cleveland Avenue.
And 126 Cleveland, what location was that?
That was the Coin Laundry.
And when you said you spoke to your sergeant, who was that at the time?
That was Sergeant Leanne Lacoste.
And was she able to provide you any information at that time about what was happening?
She gave me an overview of what was going on and indicated where I needed to go next.
And did you follow her instructions?
I did.
After speaking with Sergeant Lacoste, did you ask any homicide detective to assist you with taking control of any of this?
I asked two.
Okay, who were those two?
I asked Detective Vince Velasquez to actually go up to 2745 Old Hateville Road at Summerdale Commons and work that scene, whatever it may be. I then asked Detective Summer Benton if she could handle the 126 Cleveland Avenue. I mean, we had a car that had crashed into a building. I wanted to handle anything related to that evidence.
And did you yourself note anything of any evidentiary value at 2745 Old Hateville Road or 126 Cleveland Avenue?
Well, when I went to 2745, there were shell casings all over the ground. I don't remember how many it was at the time. Clearly evidence of a shooting. There was a disabled front gate. This really nice mechanical gate had been destroyed and it looked like fresh damage. And I wanted Detective Velasquez to take his time and go through that and report back whatever his findings were.
And was he able to do that for you?
He was.
Now, while you were on scene, were you made aware of any individuals that were detained?
I was.
Okay. How many people were detained?
3.
And who were those individuals?
I was told that it was a Frederick Prothrow, Walter Murphy, and an Adrian Bean.
Out of those 3 individuals, were you aware of any of them had injuries?
Oh yeah, I found out that Frederick Prothrow had a serious gunshot wound to the back, which changed my thinking. I mean, we had someone who was actually struck. So a lot of my energy went to that. I also found out that it was Walter Murphy had gunshot wounds to the legs. They had both been transported to Grady Hospital for treatment.
To your knowledge, did you know if Adrian Bean had an injury at that time?
I heard he had some injuries, but I didn't think they were significant based off what I learned on scene. I wasn't even sure at the time if he went to the hospital.
And you said that Mr. Prothrow, Mr. Murphy went to the hospital. What hospital did
Grady Memorial.
And did you have any investigators go to Grady Memorial Hospital to speak with Walter Murphy or Frederick Prothrow?
Yeah, I have my partners, Detective A.B. Calhoun and Detective Tracy Lewis. They would go down there and try to see if they could give me some feedback on what kind of injuries I was dealing with. I was really concerned about the brother that was shot in the back.
They said the brother. When you say the brother, what did you do?
I'm sorry, Frederick Prothrow.
And did you interview anyone while you were on scene?
Yeah, I did.
Who did you interview while you were on scene at 2745?
This young man by the name of Flores, and I interviewed the actual officer that discharged as well.
Did you interview anyone else?
I actually I didn't really interview, but I actually there was a young man by the name of Skateboard.
Did you remember his? Did you ever learn his actual name?
Brian Taylor Ransom is what I found out his name was.
When you met with investigator Robertson L, do you remember where you actually met with him?
So because this was a major scene, they pulled out all the stops. They brought out what's called the mobile command vehicle. This is an air-conditioned camper where they put the officer that's been involved in the shooting away from everyone. And when I walked into the camper, this mobile crime unit, he's in there with his lawyer. So I was, his union lawyer, the officer.
And was he able to provide you information that assisted or helped you with their investigation?
He gave me some understanding as to why he discharged his weapon. We agreed on scene that he would come back the next day with his attorney and give a formal statement at the homicide office.
And after speaking with investigator Robertson L, did you determine if there was an underlying crime that you need to investigate and was determined if he was justified in firing his weapon?
There was a shooting that prompted Detective Robertson L to discharge his weapon, as he told me. At that time, it was only an aggravated assault type investigation. We didn't know what else it may entail, but he responded to gunfire on a citizen.
And you said you spoke with someone named Flores. Does the name Eduardo Flores sound familiar?
That sounds correct.
How were you first made aware of this position?
Sergeant Leanne Lacoste told me that
I'm sorry,
That was Mr. Steele.
were you made,
I'll sustain the objection.
let me ask you this, were you just made aware that this witnesses you saw?
yes,
And was he one of them?
yes.
When you were first made aware of Mr. Flores, how long had you been on scene?
I've probably been out there about 15, maybe 20 minutes because I was walking around at each scene. That's an estimate from 10 years ago.
To your knowledge, did any other officer speak with him prior to you speaking with him?
Somebody did, but I don't remember the name.
Whoever spoke with him, do you know they recorded that first interview, that first interaction?
I didn't know any recordings with him other than what I did.
And when you interviewed him, was that your first time speaking with him?
Yes.
Do you recall, do you recall where on scene did you interview him?
I interviewed Flores at the 126 Cleveland Coin Laundry, right on the hill overlooking all the mayhem down there at the bottom where the car crashed.
You may, as long as you've shown that to the defense counsel already.
Yes, I am. I'm showing you what's been marked as Stacy Exhibit 159C. If you can take a look at Stacy Exhibit 159C and tell me if you recognize that area that depicted Stacy Exhibit 159C.
This looks pretty much like the 126 Cleveland Avenue location where the laundry was.
And in that picture, do you see the approximate area where you were when you began speaking with Mr. Flores?
Yes.
And would that picture help you describe to the jury where you were when you actually had your conversation with Mr. Flores?
So I'm between this white utility box in the picture and the driveway in that area.
So
Looking.
We'll help.
Oh, yeah.
I'm
sorry.
Your Honor, this I'm saying like the, and then Stacy Exhibit 159C.
Any objection to States 159, Charlie?
Not on behalf of Ms. Williams.
All right, hearing no objection, court will admit 159, Charlie, may be published as you see fit.
Thank you. And Detective Quinn, you should be able to erase those circles. So when the next picture comes up.
You know, I'm probably have to go back to the stick. That confused me. Where's the stick? All right. Yeah, this is better.
Now, you can go ahead and just tell the jury what you was referencing about where you were when you had that conversation with Mr. Nava Flores.
I'm in this area right around here where this cracked sidewalk is and this utility box.
And when you met with him, did he approach you or did you approach him?
He approached me. He came up to that scene. I mean, everything was cordoned off. Some kind of way he got into the scene. Someone had to have escorted him because you couldn't just walk in. Everything was wrapped up. You couldn't do nothing on Cleveland in 75 that day.
Was your interview, did you record your interview with him?
I did.
And how did you record his interview?
My digital recorder.
And where did you keep your digital recorder?
I keep my digital recorder right here in my lapel pocket. That's what I've always done.
And do you generally record all your interviews with a pocket recorder?
Yes, for the most part, yes.
And why do you record your interviews?
Well, a couple of different reasons. I want to have all the information that's coming to me on that scene so I can come back to it and reference it as I continue my investigation. I'm just big on taping things. There are times when I'll actually take a verbal and write notes. Everything's not recorded, but in this case, his interview was recorded.
What was his demeanor like when you interviewed him?
He was concerned about his vehicle that he had received from someone else.
In the course of your time as an investigator, have you ever had the occasion to meet someone who was under the influence of drugs or alcohol? As an investigator, have you ever had the occasion to interview anyone who was under the influence of drugs or alcohol?
I mean, throughout my career, almost every day.
Okay. Did Mr. Nava Flores appear to be under the influence of any drugs or alcohol when you met with him?
Not at all. He was clean.
Did his eyes appear to be glossy as if he was high or anything like that?
I didn't see it.
Okay. Was he able to speak with you coherently?
Clean as a bell.
When you first met with Nava Flores, were you aware if he had given a different version of his involvement in the case to another officer?
I did hear that.
And based on your interview with him, did he advise you what he told that initial officer?
Yes.
Did he then advise you that the version he was telling you was now in fact what he had actually?
I suppose the objection.
I sustain the objection.
Your Honor, this time I'm impeaching Mr. Nava Flores from what his testimony.
Do you have your witness on direct, ma'am? So you're gonna need to ask.
Was he able to tell you about what happened on September 11, 2013?
He was.
Was he able to tell you why he was over at Cleveland Avenue?
Yes, ma'am, he was.
Was he able to tell you who he came with on Cleveland Avenue?
Yes, ma'am, he did.
Was he able to tell you why he was in the Cleveland Avenue area?
He did.
Was he able to tell you whose car he was in?
He also told me that.
What about what car, who he gave the car to?
Yes.
Was he able to tell you if other people entered the car that he had given to someone else?
He did.
And was this entire interview captioned on that audio recording?
Absolutely.
And have you had the opportunity to listen to this audio recording in preparation for your testimony here today?
Yes, ma'am.
Permission to approach, Your Honor.
Have you shown that to the defense counsel already?
They've received it, Your
All
Honor.
right.
I'm going to show you what's been marked as State's Exhibit 160C. Tell me if you recognize State's Exhibit 160C.
This is the Eduardo Nava Flores interview. It's even got my initials on there.
And what? And have you had the opportunity to listen to that interview again in preparation for today?
I have.
And did that appear to be the full interview that you had with Mr. Nava Flores back on September 11, 2013?
That's it.
Your Honor, this time the state would like to tender State's Exhibit 160C into evidence.
Any objection states 160, Charlie?
On behalf of Mr. Wood.
All right, hearing no objection, 160C is admitted and it may be published as you see fit.
Thank you, Your Honor. 160C. You're welcome.
This Detective D. Quinn. The date is the 11th day of September, 2013. I'm currently at the intersection of Macon Drive at Cleveland Avenue. For the record, sir, what is your full name?
My name is Eduardo Flores Nava.
All right, Mr. Flores Nava, give me your date of birth, please.
It's February 2nd, 1990.
Okay. Now, we've been working a crime scene over here involving an officer-involved shooting. You just walked up minutes ago. Explain to me why you walked up here.
The reason I walked up here was because I had word that my girlfriend's car that I had borrowed this morning, might be down here in the shooting.
All right. And we're looking over the ridge here. There's a wrecker that's loading a car on. Is that Nissan Altima, burgundy in color, the car that your girlfriend allowed you to use today?
That is the car.
All right. Can you tell me anything about the car, anything specifically on how it may have arrived up here?
The only way I can think of is that we were...
Who'd you give the car to? That's all I want to know.
I did not give the car personally to anybody.
Okay, well, who did you allow to get your car?
Brian, my friend. He's the one that pointed me this direction. He's the one that had pretty much me here thinking that I was just going to grab...
Okay, listen to me. Listen to what I'm saying. Brian has told us that some guy asked to borrow the car. You let him borrow the car. If we keep going around this circle, we're going to have a long night. Let's have a short night. I'd like to go home and get a cold Peroni later on after this is all over. So tell me and describe the person, if it's true, you lent the car to.
Right.
That's all I want, so we can let you go. I don't want to interrogate you and do the hot lamps and all that shit.
Right.
Let's get it done now, brother.
Right. I got pointed this direction. I was lost. I actually do not know any of these streets' names whatsoever.
I buy that.
Right. And he was pointing me directions. I trusted him with the car. He said, "Can I borrow your car?" Yeah. I let him borrow the car. Brian.
You let Brian borrow. Where are you when you let Brian borrow your car?
I have just exited the door at what direction that the officer just...
Now, Sergeant Swartz just took you down to 2233 Macon Drive. Is that where you were when your car disappeared?
That's where I was when I was disappeared. I was in the car.
Who did you give the keys to?
Brian.
You gave them to Brian. Do you know who Brian gave the keys to?
Brian handed them over. 4 people got in the car like this.
Who's the guy you saw Brian give them to?
I don't remember, sir.
Can you describe him?
Scattered. If it was any of the guys that I just described, it was the guy with the white T-shirt and the short hair.
Was it short hair?
It was short hair.
Shorter than mine or short as mine?
It was probably as short as yours.
Okay.
And if anything,
what do you do now after the car's been lent out?
I think.
Who asked to get the car?
Brian.
Okay.
And he turned around to me and he says, "It's cool.
It's cool to let this guy borrow the car." Did you know where he was going with the car?
No, but whenever 4 black people jump in my car in the middle of Atlanta where I don't know where I'm at, I don't think
So how many black people got in your car initially?
There was 4.
You saw 4 get in your car?
Yes, there was 4.
And they were all males?
They were all males.
Okay, 4 black males. And you've described...
And now at this point, whenever they're in my car, I'm not trying to say nothing. I'm not, because there's still some people at the house. I don't know where I'm at. Obviously, this guy knows his cat, and he's doing him a favor because he said he just needs a favor. He needs to go down to the store, do something.
Do you know the guy he lent the car to?
I have no idea.
Have you ever been around him before?
Never.
Okay, all right. Anything else anything else in that first statement that you'd like to clear up now that we're here?
Yes,
Anything else?
That the gas station was just somewhere where he was looping me around, saying that we might find it.
So you never went in a gas station?
Never went in a gas
You
station.
only went to 2233 Macon?
Right. After that, from the gas station, he pointed me to 22 Macon, pulled up, got out of the car. He started talking to him. I kept my stuff because I don't know these cats.
Did you see any firearms at all during this exchange of the vehicle?
I did not. If I would have probably seen some firearms, I would have told them from those 20 minutes that we sat there waiting for the car to get back, I would have told them, look, fuck that. Why is there cops rolling by this house now? Because it wasn't but 3 minutes, 4 or 5 minutes after that the cops were just barreling down that road.
Gotcha.
And the guys that were there didn't say nothing, but they had this look in their eye like, and they looked at each other. And to me, it was just like a feeling that.
So what prompted you to leave, to come up here to Old Hateville?
Someone rolled by and said, "What the fuck happened? Something just happened. They got the whole road blocked off, blah, blah." And then they started honking at them. They left, and I said, "What?" And then they started calling. They're like, hold on, we don't know about this. We don't know about this. And they just said, like, "Yo, we have no idea if it's even our people or what."
Okay, you came up to investigate You see your girlfriend's car that was just
Right. I was walking and I couldn't find my way all the way up here because every cop that I saw, the only way I could find it is follow the cop lights.
Okay.
And that's how I got here.
I just want your buddy.
Right. And since I was here, the only reason I was saying that is because he said that we went to the gas station, and I'm like, look, I don't want you to get your buddies in trouble, or I don't know what kind of connection you got down here. I'm gonna tell them that we were at the gas station. That's what happened. We left.
All right. But you, this is the absolute truth. This second interview, right?
Second interview is
okay. We're done, man. It's that simple. All right. Ending time is 2:32 in the PM, 9/11/2013.
And was that the entirety of your interview with Mr. And I said Nava Flores incorrectly, Mr. Flores Nava?
Yes, ma'am, it was.
And after this interview with Mr. Flores Navas, did you have any additional interviews with him?
I did not.
And was this your only recorded interview with him?
Absolutely.
At any point, have you ever erased any part of this interview regarding Mr. Flores Nava?
Not at all.
Now, I want to go back to State's Exhibit 159C. Oh, sorry, 158.
58.
Looking at State's Exhibit 158C, do you see roughly the area or Macon Drive on this particular map?
Right up in this area up here.
Okay. And roughly, not that you knew exactly where he walked from, but is that roughly that area of Macon Drive where 2233 or 2233 Macon Drive was, roughly over in that Macon Drive area?
Yeah, give or take. I mean, it's probably a block or two down from where you got the blue dots.
Okay. Block or two, which way?
Not a block or two. I guess headed towards, was that Mel Burton? Would have been maybe in the middle of the road down there.
Oh, wait, hold on one second. Let me wait for this bar. If you could show us again roughly where.
I would say in this area here somewhere.
Okay.
He was able to, yes.
Now, looking at 22, excuse me, after speaking with Mr. Nava Flores, did you ever go to 2233 Macon Drive?
Yeah, I wanted to go there and see, get a feel for what he was talking about, where he came from.
And while you were down there, did you see or speak with anyone?
I did.
Who did you speak with?
Use Kayak to find the hotel you want at the price you want. Download.
And to your knowledge, who was Courtney Bean?
She told me, well, she was the wife of Adrian Bean.
And what, if anything, did you say to her about the investigation that you were currently working?
I was working a police shooting, and I had some questions about her husband's involvement.
Okay. Now, on September 11, 2013, did you canvass the area?
I did.
And what does it mean to canvass the area?
But, I had a lot of things going on. So I've got Velasquez doing the crime scene in 2745 Old Hayville. I've got Summer Benton. She's down there grinding at the scene at the laundromat. I got people at the hospital. What I wanted to do next was to get and knock on the doors of the people that actually live at the complex where the police shooting originated. And so it was during the afternoon hours. You strike out during those times of day a lot of time. I still want to knock on those doors to make sure someone didn't hear or see something I could use in this investigation.
And after canvassing the area, did you get any information that assisted you with your investigation?
It was sparse. I mean, I knocked on like 18 doors that were in close proximity to where Velasquez had been working his scene. People heard shots. People heard what they believed to be pops, things of that nature. That was good for my notepad, to know what I was dealing with. But I had no clear-cut witnesses that saw anything pertinent to the shooting.
Now, after canvassing the area and speaking to witnesses, did you inspect any of the vehicles that were involved in the shooting?
I did a visual inspection of that burgundy Nissan that was rammed into the laundromat.
Okay. And did you see anything of note or of evidentiary value within those vehicles? Within that vehicle, excuse me.
Yeah, this burgundy Nissan that crashed into the laundromat, because I got a detective on it, I was doing a quick peek. I saw a firearm in the front passenger floorboard area. I saw 2 more automatic firearms in the back seat right behind the driver and the floorboard. It was bloody cash on the ground, significant damage to the front of the vehicle. And so at that point, I was going to rely on my detective, Benton in this case, just to kind of give a deep dive into that scene, and she would get back to me.
Outside of seeing the gun in the passenger seat and the 2 guns in the back seat, did you notice any other ballistic evidence in the car?
Well, I saw what I believe to be a hole in the headrest of the front seat, passenger. Now, I don't know if it was old or new, but there was a corresponding busted out vent window on the rear passenger. So my experience is telling me a bullet probably came through here and went through that headrest.
And that, sorry.
I'm sorry, that was it.
And at that time, did you do anything to determine whether or not there was a path at that time on September 11, 2013?
Not at that time. I just need this detective to work that scene for me. I was going to, in my mind, go back in a controlled environment and probably rod out the hole. When I say rod out the hole, I was going to take something that looks just like this, stick it through the hole and see if it corresponds with that busted vent window in the back rear passenger side, and then take a picture of it. But I was going to do that later.
Let me ask you this. When you canvassed the area, you talked about people who noticed or heard some things. Did you take those people's names down and notate that for your records?
Yeah, I put their names down. The ones that answered the door, they gave me their names just to show that I was there. Jotted down some notes of what they may have seen or heard. I'm sorry, heard, because I had no eyewitnesses.
And let me ask you this. During your investigation, did any patrol officers, detectives, sergeant, lieutenant, captain, anyone from Zone 3 or any other department ever advise you of any surveillance footage from the laundromat that had any evidentiary value?
No.
During your investigation, did Detective Summer Benton, who you assigned to process 126 Cleveland Avenue, ever advise you that a patrol officer, detective, sergeant, lieutenant, captain, or any major from Zone 3 or any other department gave her any information about surveillance footage from the laundromat that had any evidentiary value?
No.
Now, after going to the scene and interviewing individuals at the scene, did you ever interview anyone else not at the scene?
Yes.
Who?
Derek Dotson.
Where did you interview Derek Dotson?
I did it at the homicide office that same day.
And what was his demeanor when you interviewed him?
He was lucid. He was clear. He gave me information about what happened to him.
Was he able to tell you, and don't tell me what he said, but was he able to tell you if money was taken from him?
Yes.
You're right, I'm asking if he was able to tell him that, not what he said.
I'm over the objection on both grounds, Mr. Steele and Mr. Sharp. You may answer the question, Detective.
Was he able, not what he said, but was he able to provide that information?
Yes, he was.
When you interviewed Derek Dotson, to your knowledge, did Detective A.B. Calhoun observe that interview?
Yes, he did.
With Detective Calhoun, to your knowledge, was he responsible with inventorying that money that you said was found on the ground outside of that red car?
He was.
Okay. And after you spoke with Derek Dotson, was Investigator Calhoun able to tell you how much money he inventoried?
Yes,
How much money did he inventory?
$970 cash.
And your Honor, Detective Calhoun did testify previously. Okay. Now, during the course of your investigation, did you have Detective Velasquez assist you in interviewing a Detective A.C. Booger Higgins?
I did.
And as a part of your investigation, did you learn a description, was A.C. Booger Higgins able to give you a description of, let me back that up. What was your understanding of A.C. Booger Higgins' role in this investigation?
Her role was, she was in the car occupied by Detective Roberson L., who was a front seat passenger, and another detective by the name of Pope.
Yes, Mr. Steele. Ladies and gentlemen, how about a comfort break? Let's take about 10 minutes, and Detective Quinn will go ahead and let you take a comfort break as well. Don't discuss testimony of anybody except the attorneys in this case. Ladies and gentlemen, we'll see you back in 10 minutes. All rise. All right, we're going to recess.
Monday.com is the ideal platform for
You have the hand for everybody back, sir?
Yes, sir.
All right, all yours,
Yes, sir.
ready? All right. All right, some of yours.
All right, for the jury. All jurors present and counted.
All right, thank you, Deputy. Ladies and gentlemen, please be seated.
Thank you, Your Honor. Detective Quinn, when we left off, we were getting ready to speak about Detective Booker Higgins, but before I do that, I'm going to show you what's already been admitted as State's Exhibit 108C. When we reference Derek Dodson, that's the individual that you met with at the homicide unit.
Yes,
Well, minus the black string across his face.
I recognize.
Okay. Now, going back to Detective Booker Higgins, what was your understanding of her involvement in this case?
She was on scene at the time when Detective Robertson discharged his firearm.
Right. And when you had Detective Velasquez speak with Booker Higgins, did she provide a description of a driver of the vehicle that was involved in this incident?
She did, yes.
Okay. And what was the description that was given what was the description that was given?
She gave a description.
Call for hearsay.
Yep. Your Honor, Detective Booker Higgins has already testified, so it's not here.
Said it was a,
I overrule the objection, sir. I overrule the objection.
Thank you, Your Honor.
Go ahead. What was the,
said it was a female driver.
okay. And did that female driver have any particular hair color?
I think she said pink. I'm not really sure. I can't remember exactly. But
Now, at this point in your investigation, were you now looking for a woman as a part of this underlying assault that you were investigating?
absolutely.
Now, during the course of your investigation, did you also have the occasion to interview a Leonard Pass?
I did.
And was he able to give you information that assisted with your investigation?
He did.
Now, permission to approach? Yes, they should have seen these already in discovery. And I believe I sent them to them previously, Your Honor. These are definitely on the discovery. From the crime scene pictures. Yes. Should be. I'm going to show you what the mark says is a 111 or 112C. Do you recognize Exhibit 111 and 112C?
I do.
And how do you recognize Exhibit 111 and 112C?
That's the area that I had a photograph. I had a crime scene tech come out and take pictures. That's my left hand pointing to a little dot on the ground there.
And is that a fair, accurate depiction of the image or the area that you had a crime scene take a picture of back in September of 2013?
Yes, ma'am.
Your Honor, this time to say like Tennessee Exhibit 110 and 111 into evidence. I mean, and 112, I'm sorry. Excuse me, 111 and 112 into evidence.
Any objection to station 110 or 111?
No, and it's 111 and 112, Your Honor, my apologies.
Station 111 and 112?
Yes,
All right, station 111 and 112 were admitted.
thank you, Your Honor. You could publish. I'm going to actually first start with what has already been admitted, Exhibit 110C. Looking at Exhibit 110C, do you recognize what's in Exhibit 110C?
Yeah, that's Somerdale County.
Okay. And now looking at Exhibit 111C. And looking at 112C. Is that your hand that you were just referencing that's pointing at something in the ground?
That's me. Yeah.
What exactly were you pointing at the
That
ground?
was what was believed to be impact from a projectile from a gun, a bullet.
Now, during the course of your investigation, did you ever attempt to speak with yourself, either Frederick Prothrow and Walter Murphy?
Yes.
And were you able to speak with them?
No.
During the course of your investigation, did you ever meet with the owner of the red car that was used in the armed robbery?
Yes.
And if you can recall, about when in your investigation did you meet with her?
I know it was a couple of weeks after, I'm going to say the latter part of September 24th or 25th, maybe.
Okay. And I said her, do you recall what her name was?
Maricela Cisneros.
And was she able to tell you information about her vehicle? Was she able to give you information about her vehicle, specifically who she had let borrow her car?
She was.
Now, during the course of your investigation, I think you talked about earlier going to do the rotting of the vehicle.
Yes, ma'am.
Did you ever actually do that with the car?
I did.
And when did you do that? Do you recall?
I don't remember the date. I know it was within the week I had the car sent to what's called the homicide cage, a protected area we put vehicles in for further processing. My goal was to understand that hole in that passenger side front seat headrest.
Did you, when you processed the vehicle, did you, or did the rotting in the vehicle, did you find any shell casings within that vehicle?
I did not.
Mr. Steele? And understanding what you knew at the time that you processed your vehicle, was that a surprise for you that you did not find any shell casings inside?
I mean, it wasn't a surprise. I mean, shell casings are fickle. You don't know where they're gonna go. You don't always find them.
Okay. In a moment, I'll be showing some pictures that I've already shown the defense counsel, but I'm re-showing to them again. Permission to approach, Your Honor?
You may have.
I'm going to show you the arguments showing the defense counsel 161 through 174C. If you could take a moment and look through 161 through 174C.
Okay, I'm done.
I'm looking at Exhibit 161C through 174C. Do you recognize those pictures?
Yeah, that's that burgundy Nissan Altima that was in the homicide cage that I wanted to get those rods through.
And are those pictures of the vehicle at the homicide cage?
Yes, ma'am.
And do those pictures appear to be a fair and accurate depiction of the car at the homicide cage when you went to process or do the rod out of that vehicle?
Yes.
You're right. This time the state would like to tender Exhibit 161C through 174C into evidence.
Any objection to stage 161C through 174C? On behalf of Mr. Williams, Your Honor, hearing no further objection, the court will read 161 Charlie through 174 Charlie, and then be published as you see.
Thank you, Your Honor. Looking at State's Exhibit 161C, if you could just orient the jury as to what we're looking at in State's Exhibit 161C.
This is just a front view of the car that made impact with 126 Cleveland at the Coin Laundry.
And let me ask you this. How does the car get from the Coin Laundry to the homicide cage?
A wrecker C, contracted record service.
And is that the record that you were referencing or talking about when we listened to the Nava Flores interview when you asked him, is that the red car on the record right there?
Yes, ma'am, it was.
All right. Now, going to 162C. Is that appear just to be another angle of the vehicle inside the Hummer? What's in State's Exhibit 162C?
It's just the front end view of where that vehicle made impact with the laundromat.
All right. 163?
That's the rear trunk compartment of the same vehicle and a rear view.
All right. And looking at 163C, is the top of the trunk on the car? The actual roof of the trunk?
I don't see where it is. I'm not seeing it.
Okay.
Looks like it's just off.
Looking at State's Exhibit 164C. What are the jurors looking at 164C?
This is that area of concern for me. Again, I'm investigating the actions of a police officer using deadly force. That's what my mind is. That vent window, the rear passenger view is what I'm concerned with and how it may correspond with that headrest of that front seat. I got a man shot in the back. I got to explain that.
Okay. And looking at State's Exhibit 165C.
That's a closer view of that same rear passenger vent window. You can also see the airbag deployed from the driver's side.
166C.
That's another view. We're getting closer. You can see that defect to the right side of that headrest. That's my area of concern. That's a through and through hole, and that was of paramount concern to me at the time.
Now looking at 167C.
That's going to be the rear passenger compartment of that burgundy Nissan owned by Miss Cisneros. You can see blood transfer. There's some items on the floor.
Now, at the time, did you request for any testing or anything to be done with the blood that was in the backseat of that vehicle?
Not the blood, no.
Why not?
I didn't think it was. I mean, I knew I had a shot person in the back seat, so I wasn't going to send off to the GBI to make sure that was blood. I mean, they don't, you know. Anyway.
All right. 168C. What are we looking at 168C?
Well, this is a very rudimentary, not very scientific. It's just a brother taking the stick. That's all I did, and running it through that hole because I'm trying to tell this story. I'm working this deadly force case, and I want to make sure that was going to be a path of a possible bullet fired by the Atlanta police.
And at the time when you're doing this, did you have information of the officer shooting into or in the direction of the vehicle?
Based off his statement, the way he broke it down, I had a pretty good idea exactly what happened.
Looking at State's Exhibit 169C. What are we looking at State's Exhibit 169C?
This is going to be an interior view of the same information, those rods. I've actually got them now going through, showing the trajectory, which corresponds with the wound that the 6'8" Mr. Frederick Prothro had to his back. Thank God the brother was 6'8", or it would have been in his head.
And outside of that bullet hole in the vehicle, did you notice any other bullet holes within the vehicle?
I did not.
Okay. Looking at State's Exhibit 170C.
It's another closer view showing the trajectory. That hole where it originates at the rear of that headdress, it's actually coming through. And I believe that is the wound that Mr. Frederick Prothro received from the Atlanta police.
Looking at State's Exhibit 171C, is that just another close-up?
That's just another of the same.
All right. 172.
It's a closer view of the rod actually coming through the headdress.
And 173. And again, 174.
173 is also the very same thing. 74 is just, that's me actually holding it, very unscientific, but just trying to tell a story.
Now, you talked about not finding any shell casings. I want to go back to State's Exhibit 167C for a moment. Now, when you were at the homicide cage, were you able to observe this vehicle in this condition as it is in this picture?
Yes.
Okay, how tall are you?
6'1".
Looking at that photo and your personal observation of looking at that vehicle, are you able to fit in the backseat of that car?
Yeah, it'll be crunched, but I'll be back there.
All right. Now, when you got to the homicide cage, was this the condition that you found that vehicle?
Yes, ma'am.
Okay. Was there, do you know, or to your knowledge, were there items in the car prior to you seeing it at the homicide cage?
On the 126 Cleveland Avenue address, there were 3 firearms that were of particular concern to me, which I had collected by the officer I delegated, or the detective, Summer Bent, to collect.
Do you recall? I'm gonna show you. I'm going to show you what's been admitted as State's Exhibit, excuse me, not State's, Defense Exhibit JW 158, 59, 160, I believe it's going to be through 169. Sure. And I actually may need Mr. Kokomo. Yes. Okay, thank you. Thank you. I'm going to show you, and Mr. Kokomo can help. I need the JW Exhibit 157. Looking at Exhibit 157, do you recall seeing those items while you were back at the crime scene, like on September 11th?
I don't remember seeing them. I mean, and I wasn't looking for them. Honestly, I mean, I delegated that out. Had a lot going on. Those guns were of importance to me at the time.
And this is the that you delegated out to Summer Bay.
Yeah, I mean, you can't do it all. You've got to depend on the people you work with to actually, execute what you needed to do. I'm in the fog of investigation. I need help, like anybody else.
So I'm gonna look at 157. Looking at Exhibit 157, can you describe for the jury how that toolbox is positioned Is it laying flat on the seat or is it kind of raised up a little bit?
It looks like the front end of it is on the seat and then it's propped up against the back of the back seat. It's like the driver's side back seat.
And is the blood underneath the toolbox?
Yeah, I see some transfer of what appears to be blood, yeah.
And to your knowledge, do you have any idea how the items got on the seat or those items were actually in the toolbox prior to this picture being taken?
I don't know anything about that.
All right. That's it. Thank you so much. Items such as that, would you have had those processed or taken to the GBI crime lab to be processed?
I wouldn't.
Why not?
I didn't feel they had anything to do with the case I was investigating, which paramount concern is the officer's use of deadly force. I had a good idea of what happened in that scene. We don't just send arbitrary items to the GBI for testing. That's a call I made. They can blame me, but I didn't think they were relevant.
Now, before we move on to the next scene, what you testified so far is a couple things that
Reading testimony.
I want to
when did this incident occur?
9/11/2013.
During the course of your investigation, did you get jail calls in this case?
I did.
Tell us a little bit about what are jail calls.
Jail calls are information stored on some server at the jail for anyone incarcerated that makes phone calls.
And how does an individual who's incarcerated make those jail calls? Do they have a PIN number? What's the process?
I don't know how they make the call, but I know how we can listen to them as law enforcement.
Okay. How do you all listen to them as law enforcement?
So there's I guess it's an app that they gave us access to. When I say they, I'm talking about the police department, the Atlanta police. At that time, you could actually punch in and listen to people in real time almost with your cell phone. It was that far advanced. You could listen to specific conversations based off the name of the inmate.
And when you listen to those calls, do you know if they are in an area called booking or if they're in general population? Are you able to determine that from the phone calls?
I can't determine it from where I sit. As I recall 10 years ago, I just know that usually when people are talking, you can.
Your Honor, cautious speculation.
Have you had the occasion to have or listen to calls that individuals make when they first get into the jail?
Yes.
Okay. And then listening to more calls once they've been in jail and maybe have gone to the general population?
Yes.
All right. Now, in this case, when did you pull jail calls in this case? For what date range?
Well, I wanted 9/11. That's the first significant data that sticks out that I wanted to see if there were any calls.
At the time on 9/11, how many people out of the 3 that you said were detained were actually taken to the Fulton County Jail?
Just one.
Who was that?
Adrian Bean.
And did you pull the jail calls for Mr. Adrian Bean?
I did.
When did you actually start listening to the jail calls?
It was several days. I think around the 16th, if I'm not mistaken.
Would you have put that date in your police report?
Yes.
We're looking at a copy of your police report, help refresh your memory as to when you started listening to jail calls.
Okay.
Okay, is that yes?
Yes.
Okay. Mr. Steele? I'm trying to copy the report. I'm going to show you what's been marked as State's Exhibit 178C. Just flip through that, tell me if you recognize State's Exhibit 178C.
Yeah, I recognize this as my supplementals.
And is that a fair and accurate depiction of your supplementals regarding this case the officer involved shooting.
Yes, ma'am.
And again, we're looking at a copy that helped refresh our memory as to the date in which you started listening to jail calls.
Okay.
And I'll specifically direct your attention to page 30 of 47. At the top and at the bottom, it might say 42.
Said 47.
30 of 47.
30 of 47.
And I apologize, it might be 32 of 47.
This one, for whatever reasons, out of order, went back to 20. Let's see, hold on. It might be me, hold on. User error, I'm sorry, hold on, here we go. Yeah, 9/16/13.
And when you started listening to jail calls on 9/16/13, did you get calls that were in between these dates?
I don't remember, I don't remember that.
Would it be safe to say that any calls you would have heard would have had to happen before you listened to them?
Yeah, absolutely.
So roughly between 9/11. In preparation for this case today, have you had an opportunity to listen to some of those jail calls that you pulled back in September of 2013?
Yes, ma'am, I have.
And in listening to those calls, are they a fair and accurate depiction of the calls that you pulled back in September of 2013?
Yes, ma'am.
And did there appear to be any additions or deletions to those calls that were made, that you pulled back in September 2013?
No.
Your Honor, at this time, the state would like to show Detective Quinn Exhibit 175, which contains calls A through C. Your Honor, State's Exhibit 175A was already admitted yesterday. State's Exhibit, 175 Charlie Alpha was already admitted yesterday, Your Honor. What is State's Exhibit 175 Charlie Bravo is actually a duplication of Defense Exhibit 205. So they've already been admitted. The other three calls, Your Honor, would be new exhibits, which would be State's Exhibits 175 Charlie Delta Echo.
You guys seem to have Alpha through Echo.
Yes, 175 Charlie Alpha through Echo.
Any objection? I just have one moment. Yeah, sure, absolutely.
Yes. There are other calls that are on those that, not all of them, they are. Just because they were on the one CD, so I didn't know you were putting it in. So when he listened to them last week, it's prior to me knowing you were putting it on. So I had already labeled it.
With Zeem, you can stream local news, sports, and events from all over the country. Zeem, always local, always free.
Prosecutors want to figure out which jail call is more. Until you get an additional 3, tell us which ones they are.
I did identify 2 of the 3 that are the newer calls that have not been admitted. I identified one, and I'll call it, for the purposes of this, the chicken call, because it stands out because she's talking about cooking fried chicken. The second call after that is a call where she's at the baseball game, and that's very identifiable. It is the third call that I advised that I will ask the court if we can take a brief break so I can just identify which call that is so that they can know. But I've identified that 2 of the 3 calls.
Do you have any objections to the baseball or chicken call? I know it's not just wrong. You have your video yet? Okay, well, why do I need more time? Because either you said to let you know if the issue comes up. Okay, but do you have any specific objections to those 2 calls? Not the third one, that we're gonna need to take a break on, as I told you. I may have, I may not, but you told me to let you know. So I told you. All right, following your direction. Mr. Steele, please don't try to engage in conversation. You're not prepared. Because if you prepared, you would have told me, you invited this conversation. I did. I asked you if you were ready. If you were ready, you said, yes, Judge, I'm ready. After you do those 2 calls. Now, if you're not ready, then go ahead and just tell me you're not ready, and we'll go ahead and I'll go ahead and we'll figure out something else to do. But if you have any other basis, then tell me. You instructed me. I raised this already. You know exactly what I'm talking about. No, I actually don't. Then we need to ask the jurors, like we need to cite for refreshment. How long is this third call? They're all 15, 20 minutes.
Right, and I will say for the third call, Your Honor, really as it relates to this particular incident, there's only 2 relevant areas from 00 to 1 minute, and then 3 minutes and 50 seconds to 6:40 are the only relevant parts, I believe, for this particular matter.
Are you gonna want all of the third call to be played? I tell you what, how long is the third call?
So all the calls, Mr. Steele is correct. All the calls are approximately 15 minutes, and the state does intend to play all 5 calls.
Your time, as much time as you want. I'm just gonna refresh your memory. No, I'm talking about the third. I'm talking about the third call. But I need the court instructed me. I don't know why we're doing this. The court instructed me to help the court. That's what I'm doing. When it comes up, that's what you instructed. So I'm following what you asked me to do. Now you're acting like I'm not prepared. I'm very. All right, I tell you what, will 20 minutes be sufficient for you to review your orders? Okay? All right. Ladies and gentlemen, we're going to take 20 minutes, and so after that, we'll come back and continue the second, we'll see you in 20 minutes. Okay?
All right, so Jordan.
All right, ladies and gentlemen, please be seated. The technical seat 20 minutes, okay?
Yes, sir.
Hey, Your Honor.
Do I need to listen to the call?
You don't, but during this break. When we come back, we'll just want to know a decision about the transcript, because we do have a transcript for the first call. And that was the one we gave to him yesterday. So just a decision
Well, I
about.
thought you were going to take more time for that because
Oh,
They-
they have not looked at it. Okay, never mind. Thank you, Your Honor.
All right, okay. We're in recess about 20 minutes.
I have a motion. I have a motion.
In regards to what, sir?
Your comment. I have a motion.
Okay, what's your motion?
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have
Mr.
no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor, I
Mr.
need
Steele,
to
wait a
make
second.
this record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it. And the court is wrong. What happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect. Okay, which call? Which call?
These calls, as you.
Okay, well then why aren't we taking them up beforehand?
The state just said just now, these are the 3 additional calls that they want to introduce.
All right. Well, then here's your response. I'm going to give you an acceptable response.
So I'm going to make my motion.
Huh?
I need to make my motion.
Judge, there's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this. Okay. I mean, like I told you, forewarned judge, a happy judge. All right. So had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they tried.
Okay. Well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at the chicken, they're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay?
Forget
You
about
you are a grown professional advocate. I'm a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No,
but
that man's life is here.
And you know
him?
you're doing a fine job in representing him.
Well,
but you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me, because I have given you all this administrative time, all these breaks to go ahead and do this. And this is what delays the presentation of this case in front of the jury.
You know, if I would have done what the state did and I'm not poking anything at Ms. Hilton, you would have said to me, why didn't you share those calls with him before? What, you were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state didn't. I'm not poking fun because I can deal with it. But
well,
the court then steps
but
in.
here's the problem. I have a problem with it, because here's at the end of the day, I got to listen to a 15-minute call.
You don't have to listen to anything.
But
you have to make a ruling.
Yes,
on
but I have to listen to it in order to make the ruling on those. And even if you said you've listened to the chicken call and the baseball call, and if you say there's other issues that come into play, it's better for us to take those things up before I ask for that jury. And I could have done that this morning. I could have done that at another point in time. So, I mean,
I raised this issue to you, and I don't remember the date, but it was days ago. I raised it, and the court said, all right, understood, and we'll take that issue up when it comes. Now, what am I supposed to do? Okay. Sit there and say no objection?
No,
exactly right.
Not at all. Not
I said, Judge, it's an issue we need to take up.
Not at all.
And in addition to that, today alone, and this happens, today alone, the state introduced 2 exhibits. I've never been given them before, ever. You know what I did? No problem. No problem. Because I think that's professional. One was a Google map. It needs to be clarified for the record that it was not done on September 11, 2013. And then a map with little dots with 0.4 miles. I've never seen before. But I didn't do anything, Your Honor. I want to move the case. But when the court, it gives me no pleasure in saying this. I believe that this honorable court is biased against Mr. Williams and or his counsel. And I ask you to consider recusing yourself, or don't do this again to me. This is inappropriate to me. I respect you, but what am I supposed to do? Sit there while you do this? I didn't do anything wrong. I did exactly what you teach me to do and the courts teach me to do.
All right.
But instead, no, I got to finish this. Then I get told to this court says by Prosecutor Love that I'm not being candid with the court and I'm misrepresenting because Mr. Bean never went to the hospital at Grady on September 11, 2013, and Miss Love has a document on the desk to prove it. I sat right in front of Your Honor at the table, at the bench, and I said, I'd be careful what you say. That's not accurate. Miss Love looked down on me and she said, it is accurate. You said, we'll take a break, figure it out. After the break, you didn't even bat an eye. Ms. Love said, yeah, I was totally wrong. Mr. Steele's right. He was taking a Grady. If I would have done that and called another member of the bar disingenuous, not truthful, no candor, and misrepresenting, you would have had me yelling in front of a jury. You did nothing. You didn't even ask Ms. Love to apologize. I don't want her apology. I don't care about Ms. Love. But I care about the court. And now if you can walk in someone else's shoes just for a minute and see what you're doing to Mr. Williams, because it's hurtful. I'm not the one wasting time. I'm here every day ready to go. I am not wasting the time. I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And it has to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever on these occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I had the responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated, and that's that's the crucible and trial of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared, but the things that I am bringing up to both of you, and I have fussed at both sides for this particular issue of not being prepared in the sense of, and the only reason it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken up. And sometimes if we've got to parse out all these things, as you can see right now, it takes time. And that's what I'm kind of concerned about, having been a jurist for a long time. So I understand that you're a zealous advocate. You in no way offend me by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the courts told you, and I certainly could have explored other options. I didn't. So I'll tell you that much, for what it's worth.
You allowed a member of the bar yesterday ask a witness who constantly is committing, respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and but sir,
I would have said that question about another member of the bar, prosecution. You would have come over the bench and said, "How dare you?" I sat there and I said, "Outrageous." You denied the motion. I think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you, the appearance, if not the reality, is not good here. I'm being—
What, to who?
To Mr. Williams.
Okay, but
maybe to the others. Maybe
you're his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that. They have the right to at least inquire about whether or not that happened. Now, whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motives to misrepresent.
But that never happened. No good
okay,
faith.
but I'm not commenting. I'm not commenting on that. That's for the jury. That's for the jury to decide.
I asked the question about a missing recording that I wasn't given of a statement made by Mr. Bean. And what you told me?
And I keep telling you.
What you told me? You said, does the state have it? They said no. You said, nothing I can do. I tried to cross on it. You sustained an objection.
Because it doesn't exist at this point in time. Now, if it exists at some point, I told you I'd say it. 1, I tell you, I apologize to you. And then 2, I'll take corrective action against the party or the entity that failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective beforehand.
We don't. That's the whole thing. You believe it. You honestly believe it. And that's true.
On September 17th, 2013, I'm recording. Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall. I don't remember anything.
Here's the thing. That's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything, but if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm speaking with the court.
Your Honor, I object.
I'm speaking with the court.
Okay.
I'm speaking
with
the court.
Let him finish, and then you can state your.
My point is, if you don't see what's going on, it's because you're not viewing it
out of the lens
But
of a
Mr. Steele,
juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that
I
is
have
certainly
nothing to do with a throw war.
no. But I mean, it's your ability as an advocate. I told you before. That's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am.
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that, my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without.
Oh, I think I've taken Ms. Love and Ms. Hilton and her colleagues to task many times.
No, I've heard you yell.
I've taken them to task as well.
I've heard you say to her, "Stop interrupting me."
That's taking them to task.
The jurors never heard that, ever. So I asked for a continuing recusal motion, and I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, when you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do, and I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now, Ms. Love.
I don't think it's a fair forum for Mr. Williams.
Okay.
And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through the, I've told you all, both sides have told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Well, I made this motion whenever I made it, and I raised it, and you said we'll get to it.
Yeah, but it's timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it kind of so I could kind of take it at that point in time? None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right. Okay. All right. Ms. Love?
Your Honor, just the state would ask that the court deny the motion for mistrial. The state has provided to the defense these jail calls. We have actually requested more than once what portions are objectionable, what portions do they not want us to play. We have sent them to the defense in a format that they can listen to them offline without having to have the actual CD in. We have had them converted for them. The objection that we got initially was put to the call that Mr. Steele essentially put in by playing the recording of the interview that Detective Quinn did with Adrian Bean. And the whole jail recording that was played during that interview was State's Exhibit 175, Charlie Alpha. So the portion that they initially said that they objected to, that third-party portion, and we had a motion on it, they actually introduced by playing the call, the interview with Detective Quinn. I have said to them, I'm certain that Ms. Hilton has communicated with them via email that we are using the jail calls. And I know I personally have asked, what do you object to? So at this point, I'm not certain why there is this motion. I object to the language that is used. I'll die if the court does this. Your Honor, the court is well aware of the times that the state has received reprimand, both in front of and out of the presence of the jury. I'm not certain where that's coming from. I would ask that the court, of course, the court has already ruled, but the notion that there is a bias, I'm not certain even where that's coming from, given the amount of tongue lashings we've received from the court on the state side. So I would just object to the defendant being granted a mistrial. And I state for the record that the portion that they identified for us that they objected to regarding the jail calls was entered through their cross-examination of the witness, Adrian Bean. Thank you.
What about the sealed document Mr. Steele is raised or made an issue of at this point?
With relation to the sealed document, that was a memorandum of the interaction that a lieutenant with the district attorney's office had with a party as it relates to Mr. Steele's interaction with that party, unsolicited, after walking out from the stand. That party made comments to members of the district attorney's office. The state asked that party, and we did not assume facts that were not in evidence. We asked, unlike the question, why did you do this? Or why did you do that? Which would assume facts that were not in evidence. We asked the open-ended question with a good faith basis for doing so, and with an ability to impeach if there was a denial of having said it. So we didn't make that up out of whole cloth. We wanted to make certain that all parties on the defense side had that random. And frankly, Your Honor, I think it is improper for anyone, for certainly any member of the bar, to stand up during the cross-examination, direct examination, and offer testimony essentially to a jury. So for Mr. Steele to stand up in the middle of my redirect of Adrian Bean and to say that did not occur, or preposterous or outlandish, is completely improper, disrespectful. The state has done nothing of the sort, and we would ask that Mr. Steele be reprimanded for doing so, and the court rightly did so. And to have him ask for an apology after he has been blatantly improperly acting before the jury, I don't know what else I could say. I would just ask that the court admonish counsel for testifying during trial. I have given the state, the court, the basis for the questions that I've asked, and I've never asked the question that assumes facts that are not in evidence. Unlike the question, why did you know that? Do you recall that? I didn't phrase my questions like that because I know not to do that, and I'm not gonna do that. And I don't want to improperly give the jury an impression of something that exists or that will be shown that I can't show them. So there is a real clear distinction in what Mr. Steele asked, implying, why did you give a statement at the hospital? And he keeps conflating what it is that is objectionable. He keeps asserting something so that everybody in the ethos is asking, oh, where is this interview? Where's this recording? He's never seen one. He doesn't have a good faith basis for asking for one. And yet he continues to put that question out there so that everyone in the universe has this idea, oh, the state is hiding something. Oh, the state destroyed evidence. Again, they sat there for a whole day asking witnesses about the destruction of evidence. There was no evidence that anybody destroyed any evidence, yet they stood there a whole day and asked someone about that. And then he asks a witness on the stand under the guise of impeaching him, do you recall that? Or didn't this happen? Or can you explain why the state would delete, or can you explain why the state failed to record your interview at the hospital? And he has no information that an interview at the hospital exists. So all of that, Your Honor, I don't know if Mr. Steele wants, to give an impression. I don't know. He's vigorously advocating for his client. That's what he is supposed to do. But I would ask that the court deny all of his motions. They are baseless. And I would ask, I've taken my licks from the court. We all have. And I'd ask that the court deny the motion for recusal. The court has made rulings that obviously the state hasn't agreed with. The court has made rulings that other people haven't agreed with. So this notion that somehow the court is biased, when as recently as a few days ago, I caught it hardest. It was played everywhere. I'd ask that the court just deny Mr. Steele's motions, all of them, out of hand.
All right. Ms. Hilton, do you have any explanation as to why this third call was just disclosed today? Is that true? Then is Mr. Steele correct?
No, he is not, Your Honor. These calls have been turned over. As a matter of fact, I'm getting ready to send an email to forward an email to defense counsel that shows when they asked us to have the calls converted because they could not hear it on a CD, they asked us to have these calls converted. Literally on January 5th, and I'm actually in the process of forwarding these calls. Mr. Smith sent these calls on January 5th, all of them. I believe a few weeks ago, this is the email that I'm looking for, when this case was first going to happen, probably in December, when we were to disclose to defense counsel what media we were going to use. I believe in one of those emails, and that is what I am looking for, I told defense counsel we're going to use all of the jail recordings. So this is not a surprise to them that we're using the jail calls. The only call that has ever been objected to is the first call that was played yesterday. They have not made an objection to any call. Now, they just want to know which of the 8 calls this is, then the state has no problem to do that. But to say that they just received the calls or they just learned about the calls, that is not true. They've known about the calls. Now, for me to identify this last call, I can do that. And I'm going to look for the email, or it might have been conversation in court, but when they asked, what media will we use? I think I said, we're going to use all the jail calls. And we're not actually using all the jail calls. We're going to use 5 of them. So this is not new evidence for defense counsel.
Sir.
About and maybe this will give a path moving forward that's a little bit more efficient, hopefully. There are thousands of jail calls in this case. So,
Your Honor, hold on. Not for this case, for Acts 5 to 7 specifically.
Okay. There are thousands of jail calls for this case. So they gave about 10, 12, however many jail calls. They're saying, I'm not going to dispute that. I don't have my computer in front of me. But it seems very inefficient to me that we're going to litigate, and you want us, the defense, to raise our objections to thousands or even 12 jail calls and suggest redactions for all these jail calls.
But when did you get the jail calls? When did they tell you? Didn't they tell you like within a week or two, like I asked before, that they were going to use these calls?
So, Your Honor, they just identified one is the chicken call. That's not how they are in discovery. So there's a cross-reference number. So we need to know exactly what call by the cross-reference number in discovery. There's nothing labeled chicken call. There's nothing.
All right, but listen, is there a certain number of calls for this particular act or acts? Yes or no?
I can't. I don't have the email in front of me. So
yes. Okay. So there's how many? 8, 10 calls? How many?
Your Honor, there's actually 8 calls, and 2 of them were duplicates. And so in the email that I broke down to them.
So in preparation, you know that if this particular act, which we've been dealing with for weeks, you only got about 12 calls to listen to, right?
So yes. So you would like us to proactively state our objections for every call and litigate, because they're not using every call.
Only if it becomes an issue, because if you all work it out, that's fine. I don't have any issue with that. But if it's going to be an issue, then I need to be able to vet it. I got to listen to the call. I got to listen to the evidentiary basis as to why it should be admitted or not admitted. That just gives me time to do that. And if you say it's only going to take about 15 minutes or whatever, well, it may take longer than that. You see how long we've been out dealing with this issue. So that's what I mean by forewarned judge is a happy judge. So if we could take it up and I don't have to either have them sit in their headquarters, it's better for all of you.
I do not dispute anything you're saying, Your Honor. All I'm doing is suggesting that if last night or yesterday we were told tomorrow we plan on playing this call and it wasn't the chicken call or the whatever call, it was whatever the number is in the discovery or on the email, then we would certainly, I would say it would be on us. But that's not exactly what happened. I just want you on, and I'm not trying to, I really like Ms. Hilton a lot, so I'm not even trying to argue with her or say she's done anything wrong. It's just, I I think if we know a little bit in advance, and it's not just, oh, the chicken call, then we would be in a better position to lodge our objections to you. Because right now they are, I assume they're getting the cross-reference numbers, so then I can bring those numbers to the defense table so we can pull up the exact calls that they want us to review. So that's kind of, I just wanted Your Honor to understand, it's not as simple as just we didn't listen to the chicken call.
Your Honor, if I may respond briefly, Mr. Williams, I believe, filed a motion in limine number 40. That was the only motion in limine that we had as it related to a jail call. And that was objecting to the third-party information contained in jail call number 175, Charlie Alpha, again, that Mr. Steele introduced by playing the interview of that Detective Quinn conducted with Adrian B. So we have again turned over the 8. We can specifically give track 1, 2, 3, 4, 5 of CD 1, 2, or 3. We can give that information to them. The way that Ms. Hilton and Atkins noted and time hacked each of these calls references specific information in the call. That is the only reason Ms. Hilton identified it as such. But there were 8 calls. There is no other call within which the information she has spoken to the court and described the call using. There's no other call that has that information out of the only 8. So I'm not certain the reason for the reference to thousands of jail calls in this particular context. But, Your Honor, we have 8 jail calls here. We've turned over. We've asked, what do you object to? And the only thing that we've gotten was motion limiting number 40 from Defendant Williams.
All right. Anything else before we recess? I still gotta allow you to listen to the phone calls.
The facts got lost. The accurate facts, I've listened to all the calls, the relevant calls. I've listened to them all. I know what the chicken call is. I know what the baseball call is. The issue is there's third parties making statements of fact, introducing statement of fact. We argued this. The state's position was it's non-hearsay because it goes to the effect of Mr. Bean, who will be a witness. I dispute that. I believe it's hearsay. That was the issue. Yes. You said, we'll take it up.
Yeah.
That's it. I'm not saying I don't understand the parameters. The only call that had issue is Madam President, District Attorney Hilton said, I don't remember what the third call is. I'll let you know on a break. I was comfortable with that. But I just want you, before these jail calls are being played, to make a ruling, because I waive it.
I need to hear the call, though.
Exactly.
Okay.
That's what, that was my objection. That was it. And I did it in a manner that I thought was appropriate to say that we raised it. Your Honorable Court told me to let you know. And then we got here.
All right. All right, N105? Yes, sir. Okay, all right, they're both denied. I'll note your objection and the continuing objection, Mr. Harvey. All right, we're gonna take, did you have something, sir? Okay, we're gonna take 15 minutes so you can listen to the call, and we'll come back at that point in time, okay? All right, we're in recess.
Pretty girls walk like this.
Thank you. Objections?
Yes, please. This is in respect to states 175 Delta.
Yes, Your Honor. I'm going to share and play the call.
Excuse me.
Not playing. But Your Honor, I believe Mr. Steele has an objection to a portion of 175C Charlie.
So
Charlie Delta, I'm sorry.
from your discussion, is it Charlie Delta or Charlie?
Charlie, 175 Charlie.
All right, what is it? Is it Charlie
Charlie.
Delta?
The
What is
first
that?
objection he has is to Charlie.
Okay,
And
and
then-
how long is Charlie?
The entire call is about 15 minutes, but
Okay, and what specifically is Mr. Steele objecting to?
the portion of the call is time-stamped 10:35 through 10:56.
Okay,
And the state intends to play that.
that's the portion that he has a specific objection as to.
Yes, Your Honor.
Okay, all right, let's play that first.
And do you mind if I sit, Your Honor?
No, not at all. Mr. Steele, is that correct? States Charlie 10:35 to 10:56?
That is correct. The state said they're playing from 000 through 125. I do not oppose. The state, assuming the foundation can be laid, state then wants to play 1039 to 1330, but I do oppose the objection. I believe it starts at 1035 through 1056.
Okay,
That is correct.
all right. Let's play it. Let me hear it.
Hello, this is a prepaid.
And Your Honor, I'm going to start it from the 10:39 to 13:30 portion of it. Well, Your Honor, I'm going to start at 10:31.
It is what it is. Yeah. But anything, what else? 100 feet of alley. He bought the lane with 100 feet. I went with the lane and y'all just say y'all didn't get lane, so what way? Oh, God, there's so much going on. I don't know what happened. I just don't know what happened. Yeah, y'all didn't play. Okay,
plus he's got to check on in that car, charges in that car, all this shit in that car. You have to check shit, cause them niggas out there be done stole all type of shit. And I don't even know what umbrella I got. Well, you know what that nigga buck boy had. I know how to cook the chicken, but I told them off the rip that Buck and them gonna go there cook their own food. Buck know how to cook. Buck gonna go to the Blue and cook their food. I wasn't going to cook them a goddamn thing. Now if that was Buck told her that people gonna cook the food, then they lied.
Yeah, you supposed to be confident and fried chicken and all that shit.
Look at my cup, baby. I already had 8 McDonald's. I don't even fall for that. I ate some Mickey D. Them folks down there, somebody, they were hungry with thug. That girl said she had some food stuff. They told me going to the store. I told them to go ahead and go to the store. They went to the store. They come back. Somebody goddamn, it's a lick around the corner. Goddamn, the nigga name goddamn red man got some money. So I said, shit, get the skateboard car then. Goddamn, y'all take skateboard car. That thing, you know, I like, fuck that shit. The nigga told me about 15, 20,000. I like, fuck that shit. I'm finna get the car and drive. That was it. That's the only time I drove out yesterday. I didn't go nowhere. I ain't been no grocery shopping with no motherfucking body. I don't know what the fuck they do. People just say shit anyway. They, what the fuck they all them folks? They can't be lying like a motherfucker. Who would even make up something like that? I ain't even said no shit like that. I ain't never cooked y'all. I sell food. When I go out there and let somebody get something to eat, I be Buck. Buck, go out there and cook your own food. Rick, go out there and cook your own food. Whoever working, go out there and cook your own food. Hey, y'all cook y'all own food. I'm not going up there cooking there for nobody, man.
Yeah, so we was out there yesterday when they showed it off out there. You know, your child came and cut the goddamn lights off on the phone. So, but they still around there, like, literally today, they been around there all day, like, I said, boy, you need to go put them folks out their house. You need to go put them out there.
Mayor, I'm sorry, we went past the 13.
Obviously.
I apologize. So, Your Honor,
All right, who is speaking in States 175 Charlie?
Sure, Your Honor. The two callers, well, the caller is Adrian Bean, and he is speaking with his wife, Courtney Bean. The portion in which Mr. Steele is objecting to is the portion from 1035 to 1056. Specifically, I'll just replay that particular portion so you can hear that again.
All right.
So he can't say.
And I'm going to start it at 1031 and I'll stop it at 1056.
It is what it is.
Yeah. Got thrown to that he said, well, like, I mean, well, like, us $150. He bought the lead with the $150. Well, what the lead that y'all just said, y'all didn't get the lead, so what about it? Oh, God, there's so much going on. I don't know what happened. I just don't know what happened. Yeah, y'all didn't play.
And I think that ends the portion in which Mr. Steele is objecting to.
Okay, Mr. Steele, what's your basis, sir?
Your Honor, it is a third party speaking. I believe the voice is Courtney Bean. That is my belief. And she is saying outside of the court, it's being introduced for the truth of the matter asserted that Jeffrey Williams, known as Thug in that call, said that they was worried about the lien, was getting the lien. I cannot confront or cross-examine Courtney Bean. And therefore, I have, as I did previously in writing, it's a third party. It's a non-testifying third party.
Is Ms. Bean coming to testify?
No, Your Honor, she's not.
Okay. Is she otherwise not available, or is she unamenable from appearing in court, or is she deceased, or what?
No, Your Honor. The state believes that this portion can be called because Mr. Steele, in playing both the interview with Adrian Bean as well as the jail call, the second jail call with Adrian Bean, in which they talk about this lean conversation, it derived from these jail calls. So when you heard the interview in which Detective Quinn is talking about the lien, or they're talking about the lien within that interview that was introduced by defense counsel, they've opened the doors for us to give context with this call as to what they're talking about.
So you're saying it's not for the truth of the matter asserted?
It is not being offered for the truth of the matter asserted in this case. And this whole conversation about the lien has already been introduced. This is what was introduced through that entire interview. So this is not being offered for the truth of the matter asserted.
What was that exhibit?
I believe that was one,
Defendant Williams?
it was the State's Exhibit 176C, 175C, Charlie.
Okay.
But we did not object to Mr. Steele introducing that entire recording, but Mr. Steele's the one who introduced it.
Okay. So 175 Charlie has already been introduced, and
Yes.
it already has this portion of the tape in it.
Yes, they're talking about the lien and all of that. Yes, it's already before the.
Okay.
I don't believe, may I have a second?
Yes, sir.
I think he asked you, is that jail recording, that section already in evidence?
No, sorry, not the jail call, just the context of the conversation. Excuse me. So let me be clear. Not the jail call. This jail call is not introduced, but the context of the lien conversation is already introduced. And we're not offering this for the truth of the matter asserted. This is giving context to all of that conversation that they were having within that interview with that Adrian Bean and Detective Quinn, that interview that they were having.
May I respond?
Yeah, sure.
Mr. Bean is interviewed by Detective Quinn. It's 176 State Exhibit. And if I'm wrong, just 156, I believe, State Exhibit.
The interview?
Yeah.
175.
Sorry, 175. This call is not played to my memory. It may be referenced, but Adrian Bean tells Detective Quinn that he was buying lien and he was robbed. You don't need to complete the story a third-party statement about lien. In fact, in these jail calls, Mr. Bean again says, I was buying lien. So the state is introducing now from a third-party non-testifying thug. Thug is interested in the lien or worried about the lien. That I cannot confront. That is an out-of-court statement, and it is offered for the truth of the matter asserted. And there's other evidence. It is not, I didn't open the door to this call. It was already in evidence that Mr. Bean said to Detective Quinn himself, he was there to purchase lien.
All right. Okay. Ms. Hilton, or Ms. Love, is Courtney Bean is Mr. Bean's spouse, correct?
Yes, Your Honor.
All right, and she's not going to testify?
She is not testifying. Your
Okay.
Honor.
If she's not going to testify, go ahead, I'm sorry.
I'm gonna say additionally, Your Honor, a few things. In addition to it bringing context, it's also effect on the listener, as well as I want to cite the court to Jones v.
Which listener?
Adrian Bean, because he's commenting on what his wife is telling him in this case. And I'm going to direct the court to Jones v. State, which is 339 Georgia at 95.
95?
Sure, it's 339.
Is it 95?
339 Georgia, Georgia at 95, and it's a 2016 case. And I'm looking at Lexus next.
I found it. So yeah. Oh, you said it's at one. Let me just find it.
It's 101.
I understand what Jones is saying, but I think Mr. Steele is saying, well, look, they're referring to his client, and he and his wife have basically inserted his client in this particular in this particular conversation.
So that's exactly what's happening in Jones v. State. So the informant.
Different because it's in Jones, you got an informant and then you got a drug sale. So those particular statements were made for the context of what a G was, a gram of heroin. So,
but the issue here in this case, Your Honor, was that the recording, they did not want the recording to come in the entirety of the phone call itself when the informant was not testifying. And Mr. Steele's argument is that because Courtney Bean is not testifying, therefore the call cannot be played. But in Jones, what Jones is saying is, although the informant was not called to testify, that recording could still be played. And it specifically says, in admitting the recording, the trial court ruled that the informant's statements were admissible to provide context for Jones' responses.
whose context? What statements are you trying to place in context?
I'm placing in Bean's context. So remember, him and his wife are having a conversation. So things that Bean is saying on this call have to be placed in context so that the jurors understand why he's responding the way that he is responding. And that is why, based upon what his wife is telling him. So
Well, what's he saying about Thug? Or that on this call? What's
they're
he saying
talking about the lien and what was happening as a part of what happened on September 11, 2013. So so her conversation is all in reference to what happened on September 11th. Remember, at this point in time, Your Honor, Mr. Bean is in jail after being going to the hospital, has gone back to jail. So they're on the call right now discussing what happened on September 11, 2013. And this is after a number of calls. So, Your Honor, and to put it really in context, this is the third call that happens after C that was entered into yesterday, as well as all came in right between 11th and Your Honor. And so all of these calls are talking specifically about what occurred on September Williams into this incident.
But it's still hearsay.
But so this also would be a prior consistent statement
Who's
because
prior consistent statement?
Adrian Bean, because when Mr. Steele was cross-examining him on the stand, he said, you only did this just to put Mr. Williams in, and Mr. Williams is just lying, all of these things. However, he had a jail recording call that was consistent with what he told Detective Quinn during his interview. So Adrian Bean's previous statement on the jail recording would be a consistent statement that he wasn't just trying to put Mr. Williams into this case just to put him in. He had already said that before his interview with Detective Quinn also. So it comes up for a number of different reasons, Your Honor, but it's a prior consistent statement. We do believe it also provides context. And so again,
Well, the predicate under Jones is it provides context.
Right.
Then you have to have a separate admissibility theory or basis. And so you're saying it's a prior consistent statement.
Yes, Your Honor. And remember that, it was all the information that Detective Quinn made Adrian Bean lie. Detective Quinn wanted Thug into this case. Detective Bean was just putting Thug into the case just to put Thug into the case. Those types of questions came out on cross-examination, and this would be evidence of a prior consistent statement of Mr. Williams' involvement in this case prior to Mr. Bean ever being interviewed by Detective Quinn. And again, lastly, Your Honor, before I sit down, Mr. Steele said that Adrian lied, but to rebut that argument of recent fabrication, again, this would be a prior consistent statement.
Well, that's what prior consistent statement does, is it rebuts prior fabrication.
Yes.
All right, Mr. Steele.
A prior consistent statement, it would be of Mr. Bean. I've only challenged Ms. Courtney Beans. This is not a prior consistent or inconsistent statement of Courtney Bean. She has not testified.
They're saying is of Mr. Bean, not his wife.
It can't be a prior consistent statement because Mr. Bean is the only one who testified. I've challenged Courtney Bean's statement. I'm not challenging Mr. Bean's statement. He talks about lien in all these recordings and to Detective Quinn. I'm not challenging that. So prior consistent statement does not work respectfully. And that's also under Tome, T-O-M-E from the United States Supreme Court, Bob, B-A-U-G-H from the Georgia Supreme Court, Adams from the Georgia Supreme Court. And the improper motive has to be challenged, and the statement has to be before the improper motive. This is the improper motive already happened, and then these jail calls. But that's irrelevant because that would be Mr. Bean's statement. I've challenged Courtney Bean. In addition to that, I think that the state is still going back to, it puts things in context. We don't need any context. He's already talking, he being Mr. Bean's already talked about lien the whole time. So I think it is for the truth of the matter asserted. It's not, and it is not non-hearsay. And I ask the court to redact that portion.
Okay. Christina? Can you tell me when we recessed?
Here, I have one reason to that portion.
Hold on. we started arguing under this. Almost 6. Oh, no. All right, Ms. Hilton, I'm back on the record, so what does he want to tell me? And I think Mr. Shard had something he wanted to say.
Your Honor, we just want to add that his acquiescence about what the.
You have to speak up, madam.
That Mr. Bean's responses to what Ms. Courtney Bean said would be an adoptive admission to his co-conspirator, which would have been Mr. Williams in this particular incident, Your Honor.
How's an adoptive admission? An adoptive admission is something along the lines of, I say that, you know, you're a child molester and you don't deny it. Or something that you would ordinarily deny.
Court indulgence for one moment.
I'm pretty sure the adoptive admission went out in January 1, 2013, but I will check.
I believe it did. But could you check, please?
Yeah, I'm looking at Carlson's, the 8th edition, and I'll look again.
I'm still here. It's still part of the OCGA section 24-8-801 D.
D2B.
B is in Barry.
D2B?
B, yes. It's still there.
Do you have any argument, or do you have any further argument as to whether or not it is an adoptive admission?
Yes.
Okay.
This is not adopted. It's not adopted by anyone. It's an admission by a party opponent. Admissions shall not be excluded to the hearsay rule. An admission is a statement offered against the party in which a statement of which the party has manifested an adoption or belief in its truth. It's a lie. The lien deal is a lie. That's the whole point. I need Miss Bean here. She's attributing something to Mr. Williams, and the state is just arguing anything to try to get it in because I can't cross-examine. So it is hearsay, and it does not fall under an exception to the hearsay rule.
All right.
But Just what Mr. Steele said. He's claiming that the lien deal is a lie. In this prior consistent statement, and this is a lie that Agent Bean made up during his interview. Therefore, we are able to bring in the prior consistent statement of him and his wife talking about this lien deal prior to him allegedly making it up during his interview. If you look at the timeline, Your Honor, these calls happened between the 11th and the 16th. He meets with Detective Quinn on the 17th. So these calls are before the alleged recent fabrication. So just like Mr. Steele just said, he's arguing that Bean made that up to Detective Quinn. Well, no, this is evidence that Bean did not make this up, that in a conversation with him and his wife is talking about what happens out and he's responding back to her. So it's his effect on the listener. It's what he's responding to about what happened on September 11th. And again, these are conversations that they were having in all of these jail calls between September 11th and September 16th, two of which have already been admitted.
Okay. All right, I'm going to exclude 1035 to 1056. I believe it is, it's hearsay. So I'm going to exclude it at this point. Okay, so we need to redact it. All right, folks, it's nearly 6 o'clock. I'm gonna just call our jurors back in. I want you all to redact it. I believe that we are going to be, tomorrow is gonna be an administrative day. I say I take up something. And then the 22nd, Friday, we'll come back at about 12:30 for a 1 o'clock start time. Mr. Shard, just have a seat just a second, okay? All right, Mr. Steele, I'm gonna just, and for others, okay? This is exactly why the court tells everybody or has told everybody ad nauseum about preparation. We started back, we had a conversation about Mr. Steele's motion and the court's response to it, but we recessed at 4:32. We came back at 5:23, and it's almost 6 o'clock at this point in time. That is exactly why the court asks all the parties to go ahead and see if you can resolve what you can resolve, or let me know so that we don't have a jury that's been parked back there for nearly 2 hours. That's why I'm kind of really incessant about us being prepared. Now, routinely, we also have, is there anything I need to take up for bringing a jury? I really don't want you all to, I do that as a matter of courtesy, but it seems like there's always something I got to take up. If we need to start coming an hour early so you all can exhaust all of those issues, we can start doing that. Because that's the challenge, and therein lies the challenge for the court. It's your jury, folks. You spent almost 10 months picking this jury. Now, and I told you that the jury who gets a chance to kind of proceed through what's being heard is better and more content. So that's why, Mr. Steele, when I said you weren't prepared, it's not because I don't think that you are a worthy adversary or you're not representing Mr. Williams to your capability. I'm just stating that this is my concern. It is not directed to you personally as a unprepared lawyer. This is just an example of why, and I think I've kind of had everybody to task at some point in time on this particular issue. It's not my intent to make you feel any way other than just do better. That's all I'm asking everybody, just do better. And just let me know whether or not we need to kind of park in place and then go ahead, and we could have probably taken this up at another day or whatever else. I cannot believe that after the amount of time you all have with this case, that you haven't gone through some of the relevant things, because we've been on the same act for a period of time. And had we and even though you might have said, I don't have any reason to doubt you didn't say, well, we need to take this up. It's just the timing and the preparation, and it could have been done a lot better. So to that extent, that's what I have. As to your motion, sir, you are welcome to file a motion to recuse me. I cannot prevent you from doing that. Certainly, if you do so, I'll deal with it accordingly. And I'm going to deny your motion for mistrial. But that's kind of where we are at this point in time. I've told every lawyer in here, this is one of my concerns as a trial judge for many, many years. I've debriefed hundreds of juries. That's something I'm trying to give you the benefit of, is not stop and start. Let's just, streamline it as much as possible. So with that, I'm going to call our jurors in. I'm going to recess them until Friday at 12:30. And then you can take up whatever else you want to. Is there anything else? Okay. All right. Summon our jurors for us, please. Sergeant Brown. Oh, Mr. I'm sorry. Before you do that, Mr. Sharp, anything?
Well, yes, Your Honor. And I understood that maybe you can take it up after the jury was dismissed, but I do now. I just want to put this on court's radar. I understand Mr. Steele's motion. I agree. I also.
What motion?
The concerns about these recordings. I also.
Detective, can I get you to step out just for a second? Okay, please, sir.
Yes, sir.
Thank you.
And.
Hold on, wait 1 second.
Yes, Your Honor.
Okay, with the recordings, you left off at that.
Yes, Your Honor. And Mr. Steele just argued about Courtney Bean's statements. My argument is that Adrian Bean's statements on the jail recordings at this point are inadmissible. And Your Honor.
Talking about the rest of it, not just the excluded portion?
Yes, all of Adrian Bean's, and this is why. There's the way I see it, there's two possible arguments. Prior inconsistent statements. The state on other recordings laid the foundation for prior inconsistent statements.
Okay, but you've examined Mr. Bean, right?
But Your Honor, if you look at, that is correct, but.
And did you examine him about these particular stuff?
No, we did not. No, we did not.
Could you have done that while he had him on cross?
Could
you have done that while you had him on cross?
I absolutely could have.
Okay, all right.
But Your Honor, the rule is the proponent. It's 24-6-613 and as well as.
We've already admitted the evidence, and that's you're talking about. I'm
not referring to the ones that were admitted. I'm referring to the other ones.
What are you referring to? Are you talking about Charlie? 175 Charlie, because that's what we're talking about right now.
Okay,
and
so
Mr. Steele has successfully argued for me to omit 1035 to 1056.
I'm referring.
So you're asking for the entirety of states 175.
Not the one that's in evidence, but my understanding is we were talking about all three: Charlie, Delta, and Charlie Echo.
The only one that there's an objection as to right now is Charlie.
Okay, I am objecting to Delta and Echo, and to Mr. Bean's statements as well. And if you look at 24-6-613, which is prior statements by witnesses, and it says, okay, excuse me, 24-801. D1C, a statement shall not be hearsay if the declarant testifies at the trial.
Which he did.
Or hearing, and is subject to cross-examination concerning the statement.
Which he was.
That's where I disagree, Your Honor. The state in certain jail calls and in Detective Quinn's interview, the state and Miss Love, and I understood what she was doing at the time. She asked very specific questions and confronted Mr. Bean with things that were said. That was not done, in my opinion, for these additional cell phone calls. She did not say, did you say to your wife, Courtney Bean, on this date, yada, 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 and have him either say, I don't recall or deny. So I don't believe the foundation was laid for a prior inconsistent statement. Now, as far as prior consistent statement, which is Ms. Hilton's, what was her stated argument, if you look at the prior consistent statement statute, which is 24-6-613, it talks about in examining, I said, it said, and it talks of consistency with the testimony. What in this case, the state, and as it appears to me, they have a prior statement which has been admitted into evidence. And if you look at Cowart v. State 294, Georgia 333, and all the other cases, they talk about to rehabilitate the testimony. There was no testimony. All we got on the stand from Mr. Bean was, I don't recall, I don't recall, I don't recall. They are trying to rehabilitate. They have a prior statement made by Mr. Bean, and they're saying prior to this prior statement, there's a motive for recent fabrication, so we want to go behind that. But I can't find any case law that suggests that you can rehabilitate a prior statement that was not testified to on the stand. So on the stand, we got nothing from Mr. Bean. So I don't believe that there's anything to rehabilitate under the prior consistent statement statute, because all we got on the stand, I think we probably all could agree, all we got on the stand was, I don't recall, I don't remember, or I don't know. And while that is sufficient to lay the foundation at times for a prior inconsistent statement, if done correctly, in accordance with the rules, I can't find any authority to say that, in Cowart, it says prior consistent statement of witness admissible only when witness was impeached by some affirmative charge that witness's testimony was tainted by recent fabrication, improper influence, or improper motive, and the prior statement predates the alleged fabrication. It talks about testimony. There's no testimony that was provided by Mr. Bean. There was just, I don't recall and I don't know. And I understand that they brought in prior statements he made, but if I read this statute correctly, the plain reading of the statute, and also I don't see any case law that would support the argument that they can rehabilitate a prior out-of-court statement with other prior out-of-court statements. And that's my argument.
Thank you, sir.
Thank you.
Ms. Love?
Thank you, Judge. 24-6-613C says a prior consistent statement shall be admissible to rehabilitate a witness if the prior consistent statement logically rebuts an attack made on the witness's credibility. A general attack on the witness's credibility with evidence offered under section 24-6-608 or 609 shall not permit rehabilitation under this subsection if a prior consistent statement is offered to rebut an express or implied charge against the witness of recent fabrication or improper influence or motive. The prior consistent statement shall have been made before the alleged recent fabrication or improper influence or motive arose. So as to the argument that it is not a prior consistent fabrication, that the prior jail call, the statements made in the jail calls prior to that are being offered to rebut against. That's as to the prior consistent statement. As to the prior inconsistent statement, Your Honor, what I did when asking Adrian Bean the questions that I asked was, did you ever at any time, I said, did you ever at any time talk with your wife about the lien and the $50 and the $150? I asked specific questions that went to, when he said, I don't recall, I would not only ask him about what he said to Detective Quinn or what he said during a specific jail call, I would broaden it and say, did you at any time during this time from September 11th to September 16th talk with your wife about X, Y, and Z? So Mr. Shart's argument that the state did not properly lay a foundation for impeachment or for prior inconsistent statements to come in is meritless, because the statute now and the case law now does not require that you, with the level of specificity as to a date and time, meet him with all of those. I asked him specifically about jail calls that he made with his wife, and specifically asked him, did you ever at any time speak with your wife about X, Y, and Z? Do you recall any conversations you had with your wife while you were in the Fulton County Jail? So the argument that Mr. Shart makes that they are not prior, that certain statements that we're arguing are prior inconsistent statements, and that we are not able to impeach Adrian Bean's trial testimony is inaccurate, because I laid the foundation for the admission of all of the statements that we're attempting to put in through the jail calls that he made.
All right.
Your Honor, just briefly under 24-6-613 says, extrinsic evidence of prior inconsistent statement by a witness shall not be admissible, and I think we can agree that this would be extrinsic evidence, shall not be admissible unless the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement or in the interest of justice.
So you didn't avail yourself of that during cross-examination, Mr. Short?
Well, but
answer my question.
I can agree with that, but I can agree with that, but the witness himself, the state is essentially saying that we can lay the foundation by saying, did you ever say this? Did you ever say that? And what I'm saying is, on the statute, it says, is first afforded an opportunity to explain or deny the prior inconsistent statement. It's still, the statute itself is anticipating that he's going to be confronted with the statement, not just with a broad, have you ever said this in your life, with the statement. And so I am arguing that state, and I'm aware of the law and what's required, and they don't need to say the date or time, but I don't believe that just saying, have you ever said this, is sufficient to confront him with that statement. And that's my argument.
And Your Honor, I did not say ever in your life. I said, did you, while you were at the jail during this time frame, did you speak with your wife about lien? Did you ever talk with her while you were in jail from this time to this time about the lien, $50, $150?
All right. Okay. All right. So based upon the arguments, your arguments in the cases that you cited, and the court's consideration, I'm going to admit states 175 Alpha Bravo Charlie subject to a redaction, Charlie subject to a redaction of 1035 through 1056. I'm going to admit states 175 Delta and Echo.
And Your Honor, those are Charlie Alpha, Charlie Bravo, Charlie Charlie, Charlie Delta, and Charlie Echo. So there's a C.
Why do you all make things so difficult?
I know. I'm sorry.
All right. All right. So state those again, Ms. Love.
State's Exhibit 175.
The ones you're offering for the purposes of this particular.
Yes.
State's Exhibit 175 Charlie Alpha.
Charlie Alpha. Hold on. Charlie Alpha.
Charlie Bravo.
Charlie Bravo.
Charlie Charlie.
Charlie Charlie.
Charlie Delta.
Okay.
and Charlie Echo. But Mr. Steele has an objection to a portion of Charlie Echo that we just haven't addressed yet, and we can address that on Friday.
All right, so so we've dealt with Charlie,
Yes,
that particular portion.
yes.
All right.
So I believe the only other objection is the Charlie Echo, and we can discuss that on Friday. Or at the court's pleasure.
Excuse me. All right, and how long is the portion, Charlie Echo that I need to hear?
And correct me if I'm wrong, Mr. Steele, but it's 4 minutes, 4:15 through 4:55 is what Mr. Steele was checking. So about 40 seconds.
All right. Mr. Steele, is that correct?
Yes, sir.
Is that what you rose to tell me, or is there something else?
Yes, sir.
Your Honorable Court admitted that exhibit ending in E. That's what I wanted to alert you, that I did have the 40 seconds that Ms. Hilton, District Attorney President Hilton said. Yes, I'm objecting to those portions, that 40 seconds.
All right, well, I'll withhold ruling then on so I'm gonna admit Charlie, it's 175 Charlie Alpha, Charlie Bravo, Charlie, I will exclude those portions from 10:35 to 10:56 on the Charlie Delta, and I withhold on Charlie Echo until I rule upon the section from 4:15 to 4:45.
4:55.
4:55. Yes, I will. Yes. I overrule, but I'll go ahead and move that. I'll authorize it to continue. All right. I want you all to come tomorrow at 12:30.
Tomorrow.
Yes, no, hold on. On Friday, the 22nd of March, I need you all to come at 12:15. We'll take up the 40 seconds before our jury comes at 1 o'clock.
Yes, Your Honor. Yes, Your Honor. Thank you.
Does that work for you, Mr. Steele, and the others?
Because on behalf of Mr. Williams.
Okay, now, do you all see the time again? It's 6:20? This is again why I kind of tell you all this. It's not just because I want to get annoyed and angry at everybody, okay? All right, but I will go ahead and remember, I'm going to excuse the jurors for tomorrow. Now, Detective Quinn, he's not available. He is available Friday.
He's available Friday, Your Honor. He's unavailable next Tuesday, Wednesday, and Thursday, but we have him Friday.
Is there any way you can ask him about his availability, or I will? Okay. I will ask him when he comes in. In fact, can you have our Detective Quinn come in, please? Detective Quinn, can you join us for a second? We're just doing some scheduling, sir.
Yes, sir.
Sir, we will not be in court tomorrow. We will be back in court on Friday. I'll need you to come for 12:30. Will that work for you?
That's going to work.
Okay, Monday the 25th of March. Are you good for that day?
Monday is clear.
All right. What about the rest of the week? 26th, 27th, and 28th?
I'm making TV on those days.
Making TV on those days?
Yeah, we got producers are flying in and we're shooting like 3 episodes.
On each day or just one of those
For
days?
2 days, and then I have colonoscopy on the 28th.
More information I want to know, but
I'm just saying. I mean,
appreciate you sharing.
I'm keeping it 100 with you, so I'm gonna be a little advocate that day.
You said on the 26th, 27th, and 28th, you otherwise not be unavailable. You'll be unavailable.
Yes, sir.
You'd be available for the 29th, that Friday.
Yes, sir.
Okay.
I can do that.
All right. State's counsel, Ms. Love and Ms. Hilton and Mr. Atkins. Do you all have any other witnesses that will otherwise be available those Tuesday, Wednesday, Thursday? If we excuse Detective Quinn for those days and have him come back on Friday? Okay, all right. Counsels for any of the defendants, do you wish to be heard on the issue of if I were to authorize Detective Quinn to be basically, we resume his testimony on Friday the 29th. Continue. Does anybody have any objection? All right, anybody else? Okay, all right. Detective, then we'll see you tomorrow, and then with that, and so I said Friday. Do you have anything else the following week if we should not fit? And the following week would be. Yeah.
We're out the first.
The week of the 8th of April, sir.
April 8th. Right now, I'm clear April 8th.
That week, should we need you for that week to finish your testimony? I don't know whether or not, I don't know what the attorneys have in terms of length, but I would say that you're going to be here tomorrow afternoon. You'll be here probably Monday, and you'll probably be here another couple of days thereafter, the week of the 8th.
Okay.
If you could block your schedule for, or at least for that week of the 8th, I believe that we could probably finish your testimony at that point.
Okay.
Does that work?
I'll try to work that out.
Okay. All right. Anything else?
No.
Okay. All right. Let's call.
All right. One more request.
Based on what happened before the jurors left our presence today, I was wondering if Your Honor would consider just giving an instruction that the delay today is not attributable to anyone. I'm afraid, quite frankly, that they'll attribute it to Mr. Steele, who represents a co-defendant of my client, and I don't want the defense to be blamed in the minds of the jurors.
I routinely, Mr. Shart, tell the jurors, and it would be error for me to do so that it's attributed to any party. So
thank you. I appreciate that.
I'm not gonna say. I'm just gonna tell them that we had to work through an issue, and I'm not gonna say any reason as to why.
Okay, thank you.
All right, summon our jurors first, please.
For the juror.
All right, ladies and gentlemen, please be seated. All right, Simon Brown, are all our jurors accounted for, sir? Say again?
Oh, right, that's everybody.
Okay, thank you. All right, ladies and gentlemen, jury, we have taken, as you can imagine, a little bit of time to resolve an issue that we had take up. Remember, I told you that these things are not to be attributed to any party. I mean, we try and work our way through them as much as we can, but that your patience is really important. So thank you for allowing us to do that. We have come to a point today where I think it'd be a natural stopping place for us today, given the fact that it is almost 6:30. And even though we switched over to daylight savings time, we still want to make sure that that you get home and at a decent hour. So we're going to go ahead and recess for today. Tomorrow we will not be in. We have an administrative day tomorrow. Remember that on Friday, what time are you supposed to be here? All right, for an anticipated 1 o'clock start time, right? Okay, all right. Then the following week, and I'll talk with y'all that in just a second. Detective Quinn, sir, we'll see you Friday, 12:15, sir, okay?
Thanks, Judge.
All right, thank you, sir. See you then. And remember, don't discuss your testimony with anybody except the attorneys in this case, okay? All right, sir, thank you. Ladies and gentlemen, we really do appreciate your patience. As I mentioned earlier, we, kind of can't, this trial of any case is not a scripted like a ballerina dance, but it kind of just stops and starts. And for your patience with us, we greatly appreciate that. Okay. And remember, I told you that we try as much as we can to kind of forecast these things, but sometimes it's not something we can do, and it just kind of comes up. We got to deal with it. And you have been more than patient with us, and we appreciate that, and we continue to appreciate that. All right. So, ladies and gentlemen, Friday you come at for 12:30. All right. The 5th, I should say the 1st through the 5th. That is your administrative pause by consensus. Do not ask me for any more pauses after that, okay? Use the time that I give you to go ahead and take care of what you need to take care of. And when you come back and we commence back on the 8th, make sure. No, because you're not here next week.
Yes.
Yes.
Hold on, did I skip a week?
Yes.
Come on.
That's okay, we'll take it.
Thank you.
You are, yeah, well, okay. Yeah, we're together all next. We're together all next week. The week of the 1st of April, you'll be out. You'll be on a pause, okay? And then we will recommence on the 8th after that week. And on the 8th, my goal will be to give you kind of a few days, and in particular, some Fridays that you can bank on at least half a day. Because as you probably already kind of figured out, about every second or third Friday, I have Veterans Court during the morning. So that's why we start a little bit later. So I'm going to try and give you those dates through the 1st of July or thereabouts. So you can go ahead, and if you need to book something that morning or whatever else, you'll know, hey, I can do it. So how about that? And I'll try and tell you the other dates that I know that we will be taking a pause on those dates. So you can go ahead and as much as you can through, I believe, I want to say July, first part of July, we should be able to kind of give you some comfort as to which days we will be actually holding court, okay? All right. What are your questions of me? Anybody? Okay. Leave your notepads in the basket. Very important that you take a juror sticker with you and have it prepared when you come back on Friday. Don't discuss what you've heard in the four walls of this courtroom with anybody. Do not do any extra research. Remember, you can only consider what's presented lawfully in the four walls of this courtroom. Please don't discuss anything that we've had amongst yourselves or with any other third parties. And if third parties should try and talk with you about this case in your presence or hearing, or reach out and try and talk with you, that you would need to as well contact myself and Sergeant Ingram immediately. Don't listen to any media accounts of the trial that you may, even when you're not in our presence and hearing, you would not be authorized to consider anything other than what's presented in the four walls of this courtroom, okay? All right. Ladies and gentlemen, do you have any other questions of me? Okay, madam in the back who disclosed to me or disclosed that the hearing, I'm working on that. Okay. I can't do anything about diction because that's regional. But what I can do is I can make sure that you're able to hear it a lot better. So we're working on a couple of things. So I want you to know that I've still kind of taken care of it. So more to follow on that in the next couple of days. All right. Okay. Anybody else? Okay. As I've concluded every day, ladies and gentlemen, we really appreciate your patience with us. Really appreciate the attention and the diligence you've given to this case and our matter. And unless you have anything else, ladies and gentlemen, I will see you on Friday at 12:30 for an anticipated 1 o'clock start time, okay? All right, we're in recess. All rise. All right, ladies and gentlemen, please be seated. Our jury has left us. All right. Are there any other ministerial inquiry or me or anything else I need to state? Anyone else?
I do, Your Honor.
Yes, Mr. Steele.
Your Honor, I don't want to waive anything, so I know the Harvey rule, but it sounds like I'm waiving. I want to adopt the exclusion of 175C, C.
Charlie.
Yes, D,
Charlie Delta.
CD, and as well as CE.
Charlie Echo.
And I want to adopt in toto the Honorable Max Sharp's argument. But with that being said, then my backfall is the redaction, like we said. The second thing is, because it's going to be a break until Friday, I have to renew my motion for a mistrial before the next question's asked. Can this Honorable Court again preserve it, that I've raised it, and I don't need to do that?
You did already.
But as long as I preserve, I don't want.
I'm going to give it to you as well, that you've already preserved that.
Thank you.
Already.
Thank you.
All right. Anything else?
On behalf of this.
All right, then at 12:15, I need everybody, the lawyers, as well as I'll make sure your clients are here, counsels. We're going to take up that 12:15, okay? So make sure you eat before then, and we'll go ahead and we'll take care of that. Should be able to rule upon it. State you should have at least have a redaction ready, just in case. And we'll take it up at that point in time, okay? All right, we're in recess until Friday. All right.